Ses.
هندوء واثنين هندوء هندوء
Ses. Deneme ses. a little bit because the flotilla passengers were having their non-violence trainings. So right after that, they were supposed to come here. Since they were on the way, we waited a little bit. Now opening speeches and speakers are here. So we better to start. Can I ask everyone to take their seats, please? Yeah. Of course, of course. Yeah, take your time. Yeah. Ömer çek. Evet. Ben her yere otururum. Problem yok. Ömerciğim. Su kahve işini bir sorsana ya.
Hello, everyone. I want to welcome you and thank you all for attending this incredibly important event discussing the legal implications of the global SUMUD Flotilla. This movement, its participants and supporters are a beacon of hope and humanity in a time where many choose to turn a blind eye to the genocide happening in Gaza. I'm incredibly excited to be presenting our speakers today, and we'll be starting with some opening speeches. I'd like to welcome Hatem Ziu to the stage, who will be speaking for 10 minutes. Thank you.
un, deux, test, un, deux, un, deux, un, deux, un, deux, test. Un, deux, test, un, deux, un, deux, un, deux. شكرا. لا لا لا هذا لا لا لا.
All right, we'll be starting in another 2 minutes. And again, I want to welcome Hatem Zhu to.
بسم الله الرحمن الرحيم. مرحبا بكم. أهلا وسهلا بكم جميعا في تونس. أولا تونس الخضراء، أرض النضال وأرض الشهداء كذلك، وأرض الوفاء للقضايا العادلة. مرحبا بكل الضيوف من كل مكان، ولكن سامحوني باش نرحب أولا بالسيد عميد كلية الحقوق والعلوم السياسية بتونس، السيد الأمين العام المساعد للاتحاد العام التونسي للشغل، وبضيوفنا الكرام اللي جاونا من كل أنحاء العالم، من اسبانيا، من الولايات المتحدة، من تركيا، من حبش ننسى من جميع الاتحاد الأوروبي، دول الاتحاد الأوروبي، من الدول العربية. مرحبا بكم، شرفتونا في هذا اللقاء، في هذه الندوة الأكاديمية الداعمة لغزة والداعمة لأسطول الصمود. رحب زميلاتي وزملائي المحامين الحاضرين بيننا وكافة المناضلين والمناضلات من كل مكان. شوف حتى بعض أشقائنا وممثلي فلسطين كذلك حاضرين بيننا، فمرحبا بهم، أهلا وسهلا. شرفتونا في هذا اللقاء الهام والهام جدا في هذه الندوة الأكاديمية، وإحنا سعداء حقيقة باستقبالكم اليوم في تونس وفي مقرات الهيئة الوطنية للمحامين بتونس، اللي اليوم نظم هذا اللقاء بالشراكة مع منظمي هذا اللقاء وكذلك داعمي أسطول الصمود البحري. فمرحبا بكم مرة أخرى في تونس، كل الشرف. وإن شاء الله هذه الندوة تميط اللثام على الوضع الإنساني الصعب والكارثي الذي يعيشه أهالينا في غزة وعلى القانون الدولي والقانون الدولي الإنساني خاصة المنطبق على مثل هذه الوضعية. فأهالينا في غزة وفي كامل فلسطين الحقيقة يعيشون اليوم تحت الدمار الشامل وتحت الإبادة الجماعية وتحت جميع أنواع الأسلحة المحرمة دوليا في تقتيل ويعني حصار ومحاولة تجويع وتهجير تخرق كل القوانين الدولية وحتى الأخلاق الإنسانية والقيم الإنسانية التي جبلنا عليها. فمن دور الهيئة الوطنية للمحامين بتونس وكافة، وهي شريكة في الحقيقة مع بقية مكونات المجتمع في تونس في تنسيقية هامة لدعم أهالينا في غزة، ونحييهم الكل. ولكن المحاماة التونسية ستبقى وكانت دائما وستبقى وفية للحق الفلسطيني، للحق الفلسطيني أولا في تحرير واسترجاع أرضه وعاصمتها القدس، وكذلك في الدفاع عن حقه في إقامة هذه الدولة وفي العيش بسلام. وكذلك اليوم أكيد أنه من خيرة الأساتذة في القانون الدولي الحاضرين بيننا اللي نحييهم ونشكرهم على هذا الحضور وعلى هذا الفرصة التي سنحت لنا كما قلت إماطة اللسان على الوضع وعلى القانون الدولي المنطبق والقانون الدولي الإنساني. فنحن اليوم من خلال دعمنا بهذه الندوة الأكاديمية العلمية، ولكنها كذلك هي نوع من أنواع مساعدة ودعم كل المبادرات النضالية لكسر هذا الحصار وكسر هذه آلة القمع التي يمارسها الكيان الصهيوني الغاصب لأرض فلسطين، وكذلك هذا الكيان الذي حقيقة لم يشبع بالدماء يوميا. حتى المساعدات، عند توصيل المساعدات على قلتها فإنه يتم تقتيل كل الفلسطينيين الذين يقفون لاستقبال هذه المساعدات. واليوم نرى حقيقة ما لم نراه ربما حتى في التاريخ العالم أجمع. وللأسف نتذكر معناها ذكريات غريبة في الحروب العالمية، ولكن اليوم الذي تتعرض له غزة وكامل فلسطين هو من أبشع أنواع الحروب والجرائم ضد الإنسانية والإبادة الجماعية لشعب أعزل يدافع عن حقه وعن أرضه ويدافع من أجل العيش. اليوم من خلال هذه الندوة سنلقي الضوء كذلك على القانون الدولي المنظم كما قلت لمثل هذه الحالات والوضعيات وللشعوب تحت الحصار وتحت الحرب والشعوب المحتلة كذلك. وهذا من منظور القانون الدولي أكيد الأساتذة اللي مش يحضروا مش يزيدوا يوضحوه، ولكن نحن في المحاماة نؤكد على أن كل هذه المبادرات هي تدخل في إطار القانون ومن حق المجتمع الدولي الإنساني الآن. فأني أنا الحقيقة شخصيا أعتبر أن المجتمع الدولي كدول لم يكن مهما كانت محاولات بعض الدول ومهما كانت معناها حتى الاعترافات الأخيرة بدولة فلسطين اللي نحيوها وندعموها، ولكن هذه المواقف نعتبرها مواقف يعني أقل ما يقال فيها ضعيفة إن لم نقل أكثر. والبعض للأسف حتى المواقف العربية والإسلامية مخزية، ومن الضروري التصريح بهذا لأنه لابد أنه اليوم تستفيق هذه الدول. ولكن الحمد لله أن هناك استفاقة الآن في العالم من خلال المجتمع الدولي الإنساني الذي تمثلون أنتم اليوم جزءا منه، وهذا ما يهمنا أكثر، لأنه في الأخير الدول ستركع تحت يعني نضالات وأصوات حرة في كامل أنحاء العالم تدعم الحق الفلسطيني وتدعم كسر الحصار وتدعم إقامة دولة فلسطين. وهذا ما نعمل عليه من أجل تكريسه ومن أجل أن يستمر. فالمبادرة مهمة، ولكن لا يكفي أن نقوم بمبادرة واحدة، فالاستمرارية والتواصل بمثل هذه المبادرات في كامل أنحاء العالم هي التي ستجعل النجاح حليفنا، لأنها مؤثرة ومؤثرة جدا. وعكس ما يقول البعض فإن مثل هذه الندوات لها قيمة كبرى ولها مكانة كبيرة ولها نتائج هامة على جميع المستويات. ونحن كما قلت سعداء باستقبال عديد الخبراء في القانون الدولي والأساتذة والمحامين المختصين، وكذلك سعداء بأنه مش تكون معنا فيما بعد السيدة فرانشيسكا البناز المقرة الأممية للحالة في فلسطين الإنسانية في فلسطين، وهذا شرف كبير أنه ستقوم بمداخلة فيما بعد وتدلي بدلوها في هذا الجانب وتؤطر المسألة من ناحية القانون الدولي. مهما كان ومهما كان فشل هذا المنتظم الأممي بين ظفرين، ومهما كان فشل هذه المنظومة الدولية، فنحن نواصل العمل على أن تستفيق كما قلت هذه الدول وهذه الأمم والمنظمات. واليوم لابد من السعي والمطالبة بشدة في تطبيق القانون الدولي، وخاصة القرارات الدولية والأحكام الصادرة عن محكمة العدل الدولية وعن المحكمة الجنائية الدولية طبعا. فالحقيقة لست اليوم سأتحدث فقط كعميد للهيئة الوطنية للمحامين، لكن شرف كبير أنه احنا في تونس مجتمع مدني الكل وتنسيقية المجتمع المدني الداعمة للحق الفلسطيني، أنه اليوم تستقبلكم في تونس وتدعم أسطول الصمود الذي سينطلق في الأيام. هو كان مبرمج ليوم الغد، ولكن المنظمين فيما بعد سيتولون توضيح المسألة، ربما بعض المسائل التنظيمية وحتى الطقس وغيره يتحكم في هذه المسائل. فإن شاء الله انطلاق هذا الأسطول من تونس سيكون في الأيام القليلة القادمة، ربما يوم السبت، ولكن إن شاء الله التأكيد يكون من المنظمين والأخ نوار. والحقيقة نحن سعداء جدا باحتضان هذا اللقاء، والأكيد أن اليوم هذه الرسالة ستصل إلى العالم أجمع، ولكن الأهم أن تصل إلى إخوتنا في فلسطين وفي غزة. لن نترككم ونحن معكم، ونحن سنعمل كل ما أوتينا من جهد كمجتمع إنساني دولي من أجل كسر هذا الحصار الغاشم الظالم عليكم، ومن أجل رفع هذه المظلمة كذلك، وإيقاف الحرب، حرب الإبادة على أهالينا التي لم تترك لا بشر ولا حجر ولا نبات، نساء، أطفال، شيوخ، يعني شيء مؤلم للقلب ولكل ضمير حي. والحقيقة أنه الضمير الدولي الإنساني استفاق، وتونس الخضراء ترحب بكم وستواصل دعمها الثابت للقضية الفلسطينية. حقيقة الموقف التونسي كان دائما تاريخيا موقف ثابت، سواء على المستوى الرسمي حكومة وشعبا كذلك، أو كذلك على المستوى الشعبي والأهلي والمجتمع المدني، كان دائما موقف ثابت في دعم القضية الفلسطينية، في دعم الحق الفلسطيني، في دعم تحرير الأرض المغتصبة لفلسطين. مرحبا بكم. سنواصل العمل من أجل رفع حتى هذا مستوى هذه المواقف في تونس وفي غيرها من الدول، من أجل الاعتراف بدولة فلسطين، من أجل إيقاف الحرب على أهالينا في غزة، ومن أجل متابعة وملاحقة كل مجرمي الحرب الصهاينة الذين ارتكبوا أبشع جرائم الحرب في حق إخوتنا وأهالينا في فلسطين. شكرا لكم والسلام عليكم.
Thank you for these incredible words. Next, we're going to hear from Wael Nauer, who is a member of the steering committee in the Global SUMUD FLOTILLA.
مرحبا بكم الناس الكل، مرحبا بضيوفنا من كل أنحاء العالم. هذه الندوة هي ندوة أكاديمية مختصة في القانون، الحق ليست من اختصاصي. أنا أتحدث كعضو هيئة التسيير العالمية للأسطول وعضو تنسيقية العمل المشترك طبعا في تونس، لأعطيكم أهم التفاصيل وآخر المعطيات حول أسطول الصمود العالمي. وقبل ذلك أريد أن أشكر بشكل خاص السيد سمير الشرفي ممثل الاتحاد العام التونسي للشغل والسيد عميد المحامين. ونحن نفخر بأن المنظمات الوطنية في تونس رغم ضغط الممولين مثل ما يحدث في كل أنحاء العالم لكي يتخلوا عن القضية الفلسطينية، إلا أن منظماتنا الوطنية في تونس تعتبر القضية الفلسطينية شيء لا يجب أن ولا يتم المساومة عليه وعلى المواقف الخاصة بالحق الفلسطيني. ولقد كان معنا الاتحاد العام التونسي للشغل وعمادة المحامين وكل المنظمات الوطنية من المجتمع المدني في تونس في قافلة الصمود، والآن في أسطول الصمود العالمي، وقبلها في كل التحركات الداعمة للحق الفلسطيني. وهذا أمر مهم لأنه الموقف الشعبي يجب أن يكون دائما هو الأصل، فالحكومات تذهب وتجي وما يبقى ولا يتغير هو الموقف الشعبي والموقف المنظمات الوطنية. وهذا نحن نفخر به جيدا في تونس. اليوم في أسطول الصمود العالمي الجهة التونسية المنظمة تضم الجميع دون استثناء مهما كان الموقف في القضايا المحلية والتي نختلف عليها، ولكن نحن لا نختلف أبدا على الحق الفلسطيني وعلى القضية الفلسطينية. ولذلك تنسيقية العمل المشترك من أجل فلسطين وأسطول الصمود يضم كل الطيف التونسي السياسي والفكري والمدني والوطني معا من أجل كسر الحصار على غزة. في الحقيقة هي ندوة قانونية، ولكن أنا أتحدث شخصيا وباسم تنسيقية العمل المشترك من أجل فلسطين. أعتقد أن القانون لا يسوى شيء إذا لم يطبق على الجميع. القانون جعل إما ليطبق على الجميع فيحترمه الجميع، ولكن لو كان القانون امتيازا يطبق على جهة ولا يطبق على جهة، يطبق على فرد ولا يطبق على فرد، يطبق على شعب ولا يطبق على شعب، يطبق على دولة ولا يطبق على دولة، فهو لا يسوى شيء. وللأسف فإن اليوم القانون الدولي والقوانين أمام أنظار كل العالم من غير رجال القانون لا يسوى شيء، والمجتمع الدولي لا يسوى شيء. فإذا كانت تتم إبادة في أمام أنظار كل العالم وأمام أنظار كل المحاكم وأمام أنظار كل الحكومات ولا يوجد يوجد قوانين ولكن لا يوجد من يفرض استعمال هذه القوانين، فذلك إشكال كبير. اليوم هناك بطاقات يعني جلب في عدد من القادة الصهيونيين، من يطبقها؟ لا أحد. اليوم هناك قرارات أممية لإيقاف الحصار، من يطبقها؟ لا أحد. ماذا يسوى هذا القانون؟ ففي الواقع من هذه الفكرة من هنا جاءت فكرة قافلة الصمود وجاءت فكرة أسطول الصمود، وتقاطعنا في هذه الفكرة نحن كقافلة الصمود المغاربي التي أصبحت أسطول الصمود المغاربي. تقاطعنا في هذه الفكرة مع أصدقائنا في الجلوبال موفمنت غزة وأصدقائنا في الناشطين في أسطول الحرية وأصدقائنا في صمود نصنطارة على هذه النقطة بالذات، وهي ما دام هناك فشل للحكومات وما دام هناك فشل للمجتمع المدني والهيئات الدولية في تطبيق القانون وليس في وضع القانون، فيجب على الشعوب أن تتحمل مسؤولياتها. ولذلك اليوم إذا كانت كل حكومات العالم أو فلأقل أغلب حكومات العالم متورطة بشكل أو بآخر في الإبادة الجماعية بين صاحب الإبادة الجماعية وبين المشارك في الإبادة الجماعية وبين المتواطئ في الإبادة الجماعية وبين الصامت في الإبادة الجماعية وبين الذي يرفع شعارات ولا يدخل قارورة ماء إلى فلسطين، بين كل هؤلاء المتكالبون جميعا على الإبادة، نحن نقوم بنفس الشيء. نجمع كل الشعوب من كل العالم لنقول أن هذه الحكومات لا تمثل مواقف شعوبها، وأن كل الشعوب من كل العالم ستذهب لكسر الحصار على غزة، وليس مجرد ناشطين معزولين أقليين. كلا، شفتم الخروج في إسبانيا، الخروج في إسبانيا كان خروج بالآلاف، والخروج في إيطاليا رغم أنه لم يتم وصار خروج رمزي يوم 31 كان بالآلاف، والخروج من تونس سيكون بعشرات الآلاف. وهذا للقول أن هذه السفن لا تحمل ناشطين معزولين لديهم موقف خاص، بل يعبرون عن موقف أغلبية شعوب العالم. أغلبية شعوب العالم اليوم تريد كسر الحصار، تريد وقف الإبادة، تريد الاعتراف بفلسطين حرة وسيدة على أراضيها من البحر إلى النهر. وهذه الرسالة التي اجتمع عليها أسطول الصمود العالمي. طبعا أسطول الصمود يحتاج بقوة أن لا يكون معزولا قانونيا ولا دوليا، ولذلك فرغم استياء الشعبي الكبير من الأمم المتحدة ومن مجلس الأمن ومن كل هذا العجز، إلا أننا نتشرف بالمناضلين والمناضلات من الذين يشتغلون في هذه المؤسسات، وعلى رأسهم السيدة فرانشيسكا ألبانيز، والتي رشحتها منظماتنا الوطنية كاتحاد الشغل والمحامين والصحفيين لنيل جائزة نوبل. وأريد أن أقدم تحية للسيدة فرانشيسكا ألبانيز ونقول لها أنت صديقة تونس ما دمت صديقة فلسطين. ونحن نريد للمجتمع الدولي وللأونروا ولكل من بقي لديه ضمير داخل المؤسسات الدولية أن يكون مع أسطول الصمود في الوضوح ودون مواربة. فنحن في الحقيقة نعتبر نحن القوة المادية لهذه المؤسسات الدولية التي تخرج في قرارات نظرية بكسر الحصار. فإذا كانت الدول لا تمارس هذا القانون، نحن سنمارسه. كسر الحصار مهمة صادقت عليها الأمم المتحدة وصادقت عليها كل الدول، لم ينفذها أحد، نحن سننفذها. ولذلك من واجب المجتمع الدولي والمؤسسات الدولية أن تعلن في الوضوح عن دعمها لهذا الأسطول الذي ينفذ قراراتها والذي يقوم بعمل إنساني يعني لا جدال فيه. في النهاية نحن عمل مدني، كلنا تلقى تدريبات لكي يمكن له أن يتحكم في ردود أفعاله، أنه حتى لو تعرضنا للاستفزاز، حتى لو تعرضنا إلى المضايقة، حتى لو تعرضنا إلى القمع، سنكون ونصر أن نكون حركة مدنية سلمية إلى النهاية، لكي لا يتم تشويه هذه الحركة ولا يتم وصمها، لأن الكيان الصهيوني ومن وراء الشركاء لا يقدرون إلا على التشويه، ومن ضمن التشويهات هو محاولة ربط أسطولنا بالعنف. نحن نحمل سلاح واحد معنا في السفن، سلاح واحد: حليب للأطفال، أدوية للمرضى، ودقيق لصنع الخبز لأهالينا في غزة الذين لا يجدوا ما يأكلون. هذه الأسلحة الوحيدة التي نحملها، وهذا ما سنحمله مع ضمائرنا ومع ضمائر كل شعوب العالم. أتمنى لندوتكم القانونية النجاح، وشكرا، ونحن على ذمتكم في أي شيء.
Thank you very much for those incredibly powerful words. If we can now welcome Melanie Schweizer to speak to us. Melanie is a lawyer and another member of the steering committee in the Global SUMUD Flotilla.
Thank you very much. First of all, I want to say thank you all very, very much for organizing this panel. Thank you to the president of the Tunisian Bar Association. It's truly an honor to be here, and we are very, very happy. Thank you for giving us the space, for making this event possible. This is possibly one of the most important events of our mission. My name is Melanie Schweizer. I'm a lawyer from Germany, and I'm a member of the steering committee of the Global SUMUD Flotilla. I'm proud to be here also with Wael together to have some opening remarks about this very important panel today. First of all, I want to just underline also the importance a little bit more about this event that we are having today, the legal panel, and all these amazing people that have agreed to come here, that have offered their words, and especially Mr. Hattem, also what you said, were very important words, to hear this also from lawyers. We are in a stage of genocide. It is not just a genocide, it is a global, collective, colonial genocide. It has been going on for almost 2 years. And I think genocide doesn't really comprehend anymore what we are seeing on a daily basis. I think also it doesn't make much sense or logic to compare atrocities. But what we are seeing is something, as Mr. Hattem was saying, is unprecedented. We have never experienced this scale of violence in our lifetimes. We have of ruthlessness, of sadism, that we are seeing on a daily basis, and it's taking a toll on all of us. It's taking a moral injury, and we are here for exactly that reason. I just want to also say briefly, as being a lawyer from Germany, lawyers in these times are especially asked because they know the international laws and regulations that we are having. And an event like this would not be possible in Germany. That is for the reason of state repression, but it's also for the reason of the lack of support from the society. And the society also, this includes lawyers and judges. And that's why I'm especially very happy to hear these words also, because we can see here that the so-called Global South is leading us at this dire moment of time in humanity, that the so-called Western states, that they have failed completely, that we see now that they don't have the moral high ground anymore, because what they are doing is beyond comprehension. We cannot stand for this. And me saying this coming from Germany now, being in Tunis, it's for us a safe haven to be here, because we are persecuted in our own countries, and we cannot understand what our governments are doing, and that includes also the legal personnel. We have few people in Germany who are very supportive, and all over Europe we are also finding each other and doing the same. What we are doing here, creating this international solidarity and coordination to fight this international global colonial racist genocide. We are doing this within our networks and legal networks all over Europe and the world, basically. But just to stress this importance, then I want to say, why are we having this mission? Because as a member of the steering committee of the Global
نقول أن هذا الأسطول هو أكبر أسطول إنساني يتوجه إلى غزة. لم يقع ذلك من قبل. بالطبع نحن نرى كل هذه المجازر والفظائع المرتكبة في فلسطين كل يوم، وهذا الأمر ينفيه الكثيرون، مع أننا نراه رؤية العين. القادة الغربيون حقا يتجاهلون ذلك الأمر وينفونه. والأمر
sun is shining, right? And the press also is doing that. Instead of going outside and looking at the weather, they are multiplying basically lies and propaganda. And we as a mission, we are here to set the record straight, to say that what is happening is not in our name, that our governments do not represent us, and that our governments have failed. They have failed. They have failed to live up to their responsibility, to their legal, political, and moral responsibility. And just as being a German, I want to stress this point especially, because coming from the country that has committed the Holocaust and that has sworn to the world that never again, we're sitting here again, and Germany is again on the side that is taking part in genocide. And that's why also Germany is accused in front of the International Court of Justice for aiding and abetting to genocide, just as is Israel. So we heard 2 days ago that the Genocide Scholar Association almost unanimously declared that this is by no doubt this is a genocide, and there's basically no way out of this anymore, but still our governments refuse to take the necessary steps. That's why we are here. We have all come our way in different paths. So I am from originally the movement to Gaza that went to fly into Cairo to try to march to Rafah. Then Wael is with the SUMUD convoy that made their way here from Tunisia towards Egypt. And then we have organizers from the Freedom Flotilla, and now we have also the Asian movement, the Nusantara movement that is with us, with Nadir, and we're very pleased and very happy about this. We have come together because we realize that our national endeavors that we are doing to pressure our governments are fruitless, because our governments are not listening to us. So we have to organize and we have to remind ourselves that no oppressive, violent system in the past, that we have experienced many of them, that they stopped their violence just out of their own mercy. They stopped because the people, there was an uproar. People were rising and people were demanding in the hundreds, in the thousands, in the millions. We know this from Mahatma Gandhi, from Nelson Mandela, from Rosa Parks, from the apartheid system in South Africa, in the United States, from the colonial system in Algeria. That it wasn't ended because the governments thought from one day to the other that they would do the right thing now. And it's just like that here. It will not end if we don't put pressure, increase our pressure, and do not escalate our endeavors as well. So this mission is here not only, to bring humanitarian aid. That is, of course, our first and foremost and most important goal. And just as being a lawyer, to put this straight, this is not aid. This is the basic minimum that the Palestinian people have a right to. So this is not a favor. This is what they are entitled to, and what they are being denied, of course, by the Zionist state of Israel, but also by the world. And then, of course, we want to create a humanitarian corridor. We want to make sure that the fleets keep coming. And this is the one part of this mission. But the other part is that we want to carry a lesson of international law. This mission is not just here to bring these basic things, because, of course, as you all know, we are a civilian endeavor that is not supported by any government or by any politicians. So what we bring is only a drop in the ocean on the side of the factual, the food and medicine that we can bring and the doctors that we carry. But what we are doing is we put our bodies on the line, because we are saying no more of this, and we are calling out on our governments to finally abide by international law, to respect the rules that they have created. They expect us to abide by the law, and we expect them to abide by the law. And that we are embarking on these waters, this is completely 180% and 200% within the merits of the law. It's our legal right to embark on these ships. It is our legal right to embark on international waters. It is our legal right to actually stop at the ports of Gaza. And I think I want to make this very, very clear, because it's very important for our narrative on this journey, because we will be attacked by information war and by defamation war. Israel has no legal right to be in Palestine at all. They don't have a right to be in the Gaza Strip or in the West Bank. They must leave there. And also, of course, all these illegal terrorist colonies, they need to leave as well. But the important point, and that is also clear by the International Court of Justice with their advisory opinion from July 2024, that Israel has to leave immediately and that all of this is illegal. So the presence there is illegal. And if they claim that they can catch us in the Palestinian waters, they cannot, because they don't have legal authority there. And we have the authority. We have the San Remo handbook in our bag. We have the humanitarian agreements. Humanitarian organizations, they are under international law not allowed to be hindered to carry and to bring humanitarian law. To hinder this is a war crime. It is also a war crime to embark on these ships and vessels and to intercept us. That's an act of piracy. And I just want to set the record straight here, because this is very important. We have, with everything that we have been doing, walked within the lines of international law, and our governments, they are obliged to protect us, to shield us, and to go along with diplomatic pressure, and if need be, to send their own fleets. The NATO is in these waters, and they must make sure that we can execute on our civil, legal, international rights. And this is going to be a moment of truth for every government to see. And just in a very brief last message, the governments, they are not doing this by their own will, as we have already understood. So we need the public, we need the civil society at home. The civil society, the legal associations, the lawyers, the people of this world, you are the wings, the waves, and the wind that are carrying our mission. and you are the protection shield, and we need you for this, because if not, then we will delve into a world where we will have accepted and normalized genocide. And this is not going to stop at the borders of Palestine. This is coming to us as well. This is going to be, we will enter into very dark times, and this is unacceptable for all of us. So with this, I want to leave it here. Thank you all so much for organizing this. And it's a very, very dire moment. I just also, with the very last message, last night, 150 Palestinians have been killed. They have been either bombed or killed by this humanitarian violence, as Mr. Hatem was saying, starved to death. This is 150 people in 24 hours. In our Western newspapers, there was not a single headline of that. There's not even reporting on that. So this is being normalized. In no place in the world this would be normalized like that. And we are here to say it's enough. And we will do whatever is possible, and we will break the mental walls of having this feeling of apathy, and that this is not our obligation. Genocide is called a crime against humanity because it affects us all. That's why it's a crime against humanity, and all of humanity has to stand up now.
Thank you very much, Melanie. And last but not least, in our line of opening speeches is Najat Darish, who is a lawyer and a member of the Tunisian Bar Association. Thank you.
مرحبا بكم الكل في تونس، مرحبا بكم في وطني العزيز. نحن هنا جميعا تقريبا لنقول أن غزة لن تموت. غزة لن تموت، لأننا نرفض أن تموت إنسانيتنا. إذا ماتت غزة لقد تموت فينا إنسانيتنا جميعا دون استثناء. وأسطول الصمود العالمي، هذه الحركة التي يقودها عديد من النشطاء، هي بالضبط محور هذا الرفض لهذه الإبادة القائمة. نجتمع اليوم إعلاميين وسياسيين وأكاديميين وأساتذة ونشطاء لنقول مرة أخرى نحن لن نصمت عن إبادة تمر على مرأة من الجميع في صمت حكومي ودولي كامل. نحن لأننا نرفض الضرب بعرض الحائط القانون الدولي، نجتمع لنقوم بمهمة سلمية أساسها القانوني واضح سيقوم بتفسيره جميع الأساتذة الأكاديميين الموجودين معنا هنا. أساسها القانوني واضح باتفاقيات جنيف الرابعة بفصلها 23.55 الذي يفرض على الدولة القائمة بقوة الاحتلال بمد كل المساعدات الإنسانية للمدنيين للشعب المحتل. نحن هنا أيضا بحماية من بحماية من دليل سان غيمو بفصله 102 و110 الذي يعتبر أن الحصار البحري على السكان المدنيين تعتبر جريمة ويعتبر انتهاك للقانون الدولي. نجتمع اليوم جميعنا كما ذكرت نشطاء إعلاميين سياسيين أكاديميين لنقدم هذا التأطير القانوني، ولنقول أن أسطول الصمود العالمي يقوم بمهمة إنسانية أساسها وهدفها الأساسي هو فتح ممر إنساني لإنقاذ الشعب الفلسطيني في غزة ولرفض هذا الحصار ولرفض هذه الإبادة. ولنقول أيضا أن كل أي اعتراض للسفن البحرية بالمياه قبالة غزة هو عمل يندرج في القرصنة البحرية وعمل غير قانوني وهو انتهاك لكل أعراف القوانين الدولية. إذن لن أطيل كثيرا لأننا تأخرنا في الوقت، لكنني أقدم فقط كلمة ترحيبية بكل الأساتذة الأكاديميين الموجودين هون. مرحبا بكم سندا لهذه المبادرة وسندا للأسطول العالمي لكسر الحصار على غزة في تونس. مرحبا بكم.
Thank you very much. And now presenting on the legal memorandum for the Global SUMUD Flotilla is Hussein Jizli, who is the Vice President of WOLAS, or the Worldwide Association of Lawyers. Thank you.
I'm a very clumsy person, as proven. Yeah. Good. Good afternoon, everyone. I'm Hussein Dishli, Vice President of WOLAS. Thank you for joining us today on the eve of Global SUMUD Flotilla's departure from Tunis. The flotilla is a civilian mission, the largest of its kind since the siege began in 2007. And this flotilla will see dozens of vessels from over 40 countries sail to break the illegal blockade on Gaza and deliver urgently needed and life-saving humanitarian aid. As well as together with Global SUMUD Flotilla, Gaza Tribunal, and National Bar Association of Tunis, we organized this symposium to examine the legality of this action, the illegality of the Israeli blockade, and responsibilities of the states, protected status of the vessels and passengers sailing in the face of ongoing Israeli genocide committed against Palestinian people in Gaza. We gather not just to speak law, but to stand with those who sail for justice. I speak today on behalf of WOLAS, a global network of lawyers and legal academics based in Istanbul, working to expose and challenge injustice wherever it hides. This humanitarian mission of Global SUMUD Flotilla is a continuation of the global will to deliver humanitarian aid to people of Gaza by challenging the unlawful Israeli blockade. Since 2007, several missions has been conducted. Dozens of UN reporters has stated for the flotilla mission of 2020 is also at stake for this mission. I quote, "The flotilla is a material manifestation of international support for the ongoing Palestinian struggle for freedom and self-determination, and the internationally recognized right to receive humanitarian aid without interference or hindrance." Quote end from UN reporters. Just like the previous flotillas, this flotilla's demands are very clear: immediate and unconditional and permanent ceasefire, unrestricted access to humanitarian aid, and an end to illegal blockade of the Gaza Strip. In March 2024, the International Court of Justice, through binding provisional measures, determined that the killings, displacements, conditions of the famine and starvation in Gaza amounted to a plausible risk of genocide. Under the Genocide Convention, and accordingly, the court issued strict provisional measures against Israel in January, March, and May. In November 2024, International Criminal Court, ICC, issued an arrest warrant for Benjamin Netanyahu for the war crime of starvation as a method of warfare as well. But after that, and just like before that, these decisions didn't change anything, yet Israel brazenly escalated its criminal policies by declaring numerous times a complete ban on the entry of all goods into the Gaza Strip. An unambiguous act of collective punishment and flagrant repudiation of binding international legal obligations, carried out in an open defiance of ICJ's authoritative orders and ICC's prosecutional mandate. What's worse, Israel doesn't only use starvation as a method of warfare, but also using humanitarian aid as a method of warfare. As all of you know, the so-called humanitarian aid mechanism imposed by Israel and US, so-called Gaza Humanitarian Foundation, is a death trap, one that instrumentalizes aid, instrumentalize aid to displace, humiliate, and confine the civilians. It's obvious that international law is currently failing. and has historically failed. Historically failed Palestinians since 1948. The ongoing Israeli genocide in Gaza, 77 years of ongoing Nakba, 77 years of incremental genocide, 77 years of apartheid, dispossession, and denial of basic rights and freedoms. Gaza took off the masks and shown us a very well-known truth by some of us, by probably all of us in this room. Today, international law can no longer be seen as merely a discipline that addresses the crisis. It has itself become a discipline in crisis, as a respected scholar, Nitina Tzovola, wrote in one of his recent articles. Therefore, when we reflect on international law, we must not only approach to law as a mechanism for resolving and regulating disputes and crises, but also examine it critically, its roles as a producer and perpetrator of this very crisis. The genocide in Gaza also cannot be decontextualized from the systematic oppression endured by the Palestinian people since the Nakba. It's rooted in a broader history of colonialism. The colonial domination and alien subjugation that Palestinians are exposed to is not an isolated event, but part of a continuum that reflects the persistent influence of colonial structures on contemporary international law. Gaza has shown us very clear that there is an urgent need to dismantle the colonial structures and mechanisms born of them. This includes challenging the so-called universality of international law, which often masks Eurocentric and state-centric biases that marginalize non-Western perspectives or global South perspectives. The genocide in Gaza has exposed the limitations of this universal so-called legal order, particularly in its failure to protect colonized people. It has underscored the urgent need to rethink international law, particularly in the context of decolonization and right to self-determination in the sense of full sovereignty over the sea, land, and air, as well as societal catharsis. Even today, almost 2 years into genocides, states are failing to meet their binding obligations under international law to prevent, halt, suppress, and punish genocide, and also the starvation imposed by Israel in Gaza. States are today aggressively policing refugee movements, yet they didn't show 1% of this effort to police genocide. Instead, many states still supply Israel with weapons, resources, and political cover, conduct that may amount to complicity in international crimes, including genocide. In response to this failure of state responsibility, civilians such as those participating in this flotilla are engaging in a lawful direct action to safeguard and realize Palestinian people's fundamental entitlements under international law. It is in this legal and political vacuum created by the states and actors who has capacity and responsibility to prevent happening of this grim picture before us today. It is this vacuum that when it is the familiar motto of the previous missions, when states fail, we sail. That's exactly, that's a very good definition of the vacuum that is the motivation behind this very mission as well. I've been serving Freedom Flotilla Coalition as a legal advisor since 2024. In every mission or our attempt for sailing, Israel did everything to sabotage the mission, tried to scare away the flotilla participants, failed. Then launch all kind of bureaucratic warfare to stop flotilla vessels before sailing. Israel utilized its influence over incumbent or potential flag countries, port countries, since April 2024, waged threats on them, but only on them, not only on them, but also authorities registering vessels class, insurance, etc. A number of times flotilla flags has been withdrawn by flag states, and some of ships were with 800 to 1,000 passenger capacity. That particular ship, Akdeniz, sadly, is still waiting to obtain a flag from a country willing to grant it. A number of times, as I said, eventually with the conscious ship failing to stop it before sailing, Israel directly attacked the ship, endangering the lives of passengers around 2 nautical miles to Malta. When all this happened, we announced that we will sail sooner than sabotagers are expecting. And now we are sailing as Global SUMUD Flotilla in an unprecedented manner. We sailed, we are sailing, and we will be sailing until Palestine is free and fully sovereign over its land, aerial space, and sea. I know this was a little bit of a detour. I was supposed to present the legal memorandum, but I thought suffocating the whole room with legal technicalities, which is characteristic to law, the law that Franz Kafka himself making you feel like chewing a sawdust. So I wanted to save you from that as much as possible. I'm sure I did you a favor. So instead of presenting the legal memorandum from beginning to end, which we have written with my respected colleagues, and the reports will be soon, memorandum will be out soon in the Global SUMUD Flotilla website. So for the scholars and lawyers and all the passengers, it's always there as a reference. Instead of that, I would like to just present the central arguments and the critical points in the legal memorandum. Of course, the legal memorandum is for and foremost answer the question of why this mission is lawful under international law. And in order to do so, since the very phenomenon of blockade justifies this vision, the memorandum starts with analyzing the illegality of Israeli naval blockade over Gaza, which is exercised since 2007. Israel's naval blockade imposed on Gaza since 2007 is unlawful. I don't want to give premises, but it's just, this is not very orderly premises, but for my mind organization, forgive me, I need to articulate. Argument one, the vessels, as you know, are primarily subjected to jurisdiction of their respective flag states. Potential interception of these vessels by any state on high seas amount to violation of the sovereignty of the flag states and unlawful use of force under international law. We have witnessed this with the recent Medellin and Handala attacks. Since there are criminal filings in the UK, hopefully they will be prosecuted properly on these crimes, since it is the extension of UK territory, since the ships were carrying UK flag. Since the one of the accepted arguments in armed conflict in the sea is that naval blockade applies to international law, international armed conflict. And in order something to be international armed conflict, it should be between states. Given that Israel doesn't recognize Palestine as a state, I am now just actually deconstructing Israeli argument. Israel doesn't recognize Palestine as a state, yet claiming for naval blockade. Of course, it doesn't matter if Israel recognizes Palestine as a state or not in order for international law to characterize a blockade legal or not. But here is the thing, from Israel's viewpoint, the very category of blockade, non-existent, because not recognizing Palestine, at least it is incoherent with itself. This is not one of our central arguments. I just wanted to start with an awkward Israeli position. For your information, in the Turkel report, which was written by Israeli commission right after Mavi Marmara attack, which was, if I'm not wrong, 4 volumes, the whole argument was, despite we don't recognize Palestine as a state, why naval blockade applies. They were trying to create this exceptionalism and trying to argue that, well, that ship sailed, now the nature of armed conflicts changed, so it should be a thing, and there is a so-called significant state practice about prize issues in the sea, and in last 100 years only there are 3 state practice, and one of it is Israel. So it's also tautologic to justify something with state practice by your very own state practices. This is just one thing. So we started with the total awkwardness, and I wanted to start with invalidating that. So if you ever talk to an Israeli legal scholar doing maritime law, the main argumentation will be around this. And in this case, when blockade is not a category, applicable legal framework will shifts to the law of the sea. Argument 2, now setting aside the nature of the armed conflict in the sea, it is still, Israel insisting on exercising naval blockade is still fallacious and basis under international law, because Palestine, as acknowledged 2 times in the Wall Advisor Opinion and 2024 19 of July Advisor Opinion, Gaza is occupied. Palestinian people has a right to self-determination, and customary international law prohibits all forcible measures against people's self-determination. Consequently, Israel's sustained enforcement of control over land, sea, and air in Gaza using forcible means constitutes a continuous breach of international law. That's why, since the framing of the questions to ICJ for the advisor opinion in 2024 wasn't particularly about the naval blockade, of course, in the analysis, in the advisor opinion, naval blockade wasn't engaged in. But if it was, what we have in the advisor opinion is enough to extend the argument that advisor opinion by extension acknowledged the blockade as illegal, because, as I said, international law prohibits all forcible measures against self-determination, people's self-determination. Argument 3, now going into more technical. Interestingly, this is an argument from London. Declaration concerning the laws of naval war. This is London Declaration from 1909. So, following the conflict, now Gaza is occupied Israel is occupied force in Gaza, which is acknowledged by advisor opinion as well, thereby unquestionably subjecting itself to the law of occupation. As an occupying power, Israel is precluded from applying the blockades to these areas. I know this is an interesting argument because it's coming very interesting colonial place. Moreover, beyond the illegality of continuing the blockade, under these circumstances, Israel has not only obligation to permit relief schemes, but also facilitate them by all means at its disposal. Why, as an occupying power, Israel is precluded from the blockades to these areas? The Declaration concerning laws of naval war, London, Article 1, actually stipulates this. Even the most colonial legal, an attempt to codify the customary international law states this, because the focus wasn't really about settler colonial context like Israel. The focus more like by codifying the naval warfare law. In fact, actually, it operates as a judicial instrument of imperial consolidation, a technocratic veil for securing Euro-Atlantic maritime hegemony. By the time there were colonized regions and there were colonizers, but for the supply to go on, there was huge need for neutral states. And arbitrarily intercepting the ships of these neutral states was harming the very colonialism and capitalism. So in order to secure a stability to capitalism, in London Conference, the colonial powers stipulated that in order to protect the supply chain, if you are occupying a land, you don't need to apply a naval blockade because it's absurd, you are already on the land. So this was more like protecting the maritime mobility. Of course, London Declaration is not the central legal reference. It is more like Sandre Memorial. We will come to that. Okay. So do you need to go or shall I just wrap up? Okay, I'll wrap up. Okay. I still have 20 pages, but yeah. No, just joking. Okay. I'll be quick and then we'll be in more basic terms and only will go technically when it's needed in last 5 minutes. Under international humanitarian law, as we know, and the law of sea, naval blockade is prohibited if it inflicts disproportionate harm on civilians. It has the purpose or effect of starvation of civilian population. If it prevents access to humanitarian relief. This is San Remo Manual on International Law, Articles 102. This is, of course, a restatement of customary international law. And Fourth Geneva Convention, to which Israel is a party, whether it's a customary law or convention, doesn't matter, Israel is a party, prohibits collective punishment, and additional Protocol 1 forbids starvation of civilians as a method of warfare. So the very practice of starvation as a method of warfare invalidates the naval blockade as stipulated in San Remo Manual. Thus, the relevant legal body to apply, legal framework to apply to our situation is not IHL or armed conflict, it is human rights law. We are civilians, this is a peaceful mission, and the mission's main aim is to provision of humanitarian aid to Gaza, which was already in the provisional measures of the ICJ. So Israel's unlawful blockade has been condemned also various times by UN bodies and experts. I'm not gonna go deep into law of the sea, but in brief terms, our mission has a right to freedom of navigation because it falls under none of the exceptions in UNCLOS 110, such as piracy and smuggling or carrying the same flag as the belligerent party or unlawful broadcasting. None of it applies to us. Thus, our mission has a right to freedom of navigation. Secondly, since it is neutral to any states on the route of our journey, since it's a neutral and non-political to the coast states that we are passing through, the mission itself has also right to innocent passage. And thirdly, we have a right to humanitarian passage. I'm sure Luigi will actually go deep on that. That's why I leave it here in terms of law of the sea. And in short, why this mission is lawful? The blockade is illegal. Therefore, any use of force by Israel to enforce it is also unlawful. Breaching such a blockade or challenging to deliver humanitarian aid in itself a lawful act. The mission is humanitarian, carrying aid, no arms. It respects navigation law, exercising freedom of navigation and innocent passage rights, and violates no unclosed exceptions. Participants are protected civilians as well, even given the interception if they are abducted by Israel under Geneva Conventions. So they have to be treated humanly, and Israel should refrain from mistreatment or degrading treatment. Okay, now I conclude with what is going to happen if the ships are intercepted. First of all, there is flag state obligations and the flotilla is sailing under a number of flags, countries' flags, and they have sovereignty responsibilities and mechanisms against Israel. Secondly, home state protection. Every citizenship is Israel needs to allow all the legal visits and consular visits and legal support to passengers by the relevant consular authorities under Vienna Convention, Consular Relations, Article 36. Universal jurisdictions, any war crimes against humanity or genocide, any action falls under this, can be prosecuted in many countries around the world. And international accountability, we are already preparing an ICC file about conscious Medellin and Handala attacks. If these ships are intercepted, this will be in the same application to ICC, and we will make sure that our filing will be communicated to every ICJ judges. As concluding, I would like to say that I would like you to know that we are working closely with a number of governments, and we are mobilizing legally and diplomatically. We are mobilizing the word diplomatically and legally. And the measures and legal accountability mechanism I just stated will definitely be followed. Lastly, for the passengers, we need thousands of eyes for every passenger on the ship. So their mind should be at peace. For every passenger, we will be thousands of eyes, arms, and voice. And finally, I extend my deepest salute to heroic people of Gaza. You set such a precedent that they took the mask of all the oppression and hegemony in the world. And you resisted, and you shown what resilience and resistance mean. You resisted against, and have been still resisting against a colonial subjugation and alien domination. And under this weight of devastation, you continue to unmask the hypocrisies of global political system and international law, strip bare facade of liberal humanitarianism, and inscribe a new precedent in a grammar of liberation. Your endurance is not only a defiance of injustice, it is a word historical assertion of life, dignity, and refusal. Gaza is not merely enduring, it is teaching. Assalamu ala arwah shuhada. Thank you very much for listening to me.
Now we'll be taking a 15-minute break, so you can take the time to get a coffee or water. We'll be back for our panelists in 15 minutes. Thank you very much.
Ladies and gentlemen, we are just waiting for Francesca Albanese to connect our link. We will start within 2 minutes.
Hi, Francesca, do you hear us? Oh, I'm afraid we won't be able to. No, not that one. Hello, can you hear me?
Hello? Oops. Hi.
Hi, Francesca. Sorry, we have a connection problem here.
Okay.
And so
Thank you so much. Everyone is very excited except me because I'm really upset not to be able to be with you in person. I mean, but however, I'm so glad that you're there. And it's been 2 awful years with very small occasions of joy. And I have to say that all the occasions of joy have been connected to the departure of the flotilla. And one boat has ignited, I mean, I'm not the only one, has ignited joy. Now seeing this, I call you the army of moral warriors, because you are, it's not rhetoric. And so I'm so excited to see you doing what you're doing. So there are 3 things I know that it's great to have so many speakers, and I would like to listen to some of them as well. So I will try to be very, very short, but there are 3 things that I absolutely want you to know, and not because you don't know it, but it's just because I want it to be on record. Not only what you are doing is absolutely legal, the departure of peaceful missions to deliver humanitarian aid to the civilian population besieged and devastated, destroyed, and under ongoing and unfolding genocide, is an incredible gesture of humanity, and it's absolutely 100% lawful. What is unlawful is what Israel is doing, not only occupying, practicing apartheid, and committing genocides together with other war crimes and crimes against humanity, including starvation against the Palestinian people, first and foremost in Gaza, but also the threats that members of the Israeli government direct at you are absolutely appalling and unlawful. Unlawful. It is your right to go through the waters and sail up to Gaza. To those of you, or to those who say that, yeah, but what can you deliver? It doesn't matter the aid that you can carry. What is important is that you manage to break the siege. This is what is needed. And I'm really sorry. This is the second thing I wanted to say. I'm really sorry that you have to take this upon yourselves, because I know it shouldn't be civil society activists compelled to risk their life at sea. Had the member states of the United Nations, had our states taken decisive actions to ensure the safe and unimpeded delivery of humanitarian aid to Gaza, and a permanent ceasefire, and the end of a genocide and ethnic cleansing of the Palestinians. So thank you for taking the risk for all of us. Now, the third thing I wanted to tell you is that I want to see all of you coming back safe and from Gaza. And I encourage you not to take risks. I mean, I've been connected to the first flotilla of this, or actually to the Madlin, not the first, the second flotilla of this year. And I was with them on the phone as they were intercepted. And I will never forget the calm, the peacefulness, something that Tiago, the captain, said: don't say bad words, just because everything is being recorded. Please remember this, whatever happens, stay calm, stay peaceful, because you, where you are, you will represent all of us and all Palestinians, and what the Palestinians need is peace. Stay safe, and we will make sure that you reach destination safely, and if not, we will continue. Thank you for doing this on behalf of all of us. Thank you.
joining us here today. Thank you very much.
Yeah. Yes, yeah.
Bye. Bye. We are going to connect Luigi Daniel. And after Luigi, all of our speakers will be in person. We will save you from the we will save time. Sorry, guys. Sorry, I lost the track. Yeah. Earlier, when she was speaking, Francesca asked she wanted to see the saloon, so that's why I took that picture. Can I have the link for Luigi? Would you like to have at least Luigi?
What? Where's Luigi? What do you want me to do?
Just what I said.
You want me to moderate?
No, just welcome and that's it.
Oh, okay.
Yeah, I would like you to know.
Are you okay?
Just Luigi. Yeah.
Okay. Are you okay? You're just really tired. No, I understand. Okay. Yeah. No, I got it. Hi, Luigi.
Good afternoon. Can you hear me and see me?
Hi, Luigi. It's Heidi. I'm just going to take over for a moment to welcome you with us, to express our sadness that you can't be here in person, but are a delight, of course, that you are with us. Nevertheless, we are a bit behind in schedule, so I will turn it straight over to you. Thank you.
Thank you so much, Heidi, and thanks so much to the organizers, because I can only imagine how heavy is the burden of organizing in the heat of one of the most difficult moments of this global battle. I want to start by telling you that it's really an honor having the possibility of contributing. And I want to homage this honor by sharing with you something that was said by one of the greatest living Jewish intellectuals. I don't say the name because I haven't been authorized from the person to say this, but I think the person wouldn't mind. Is someone belonging to Jewish Voice for Peace, who shared this in one of the first meetings of the preparatory meetings of the Gaza Tribune in London. It has to do with the concept of SUMUD. They told us that in one of their first trips to the occupied territories, they visited, if I remember well, the military prison of Ofer, in which right in that moment, while they were outside, the Israeli military was conducting interrogations against Palestinian political prisoners to extort from them confessions against each other. And we know from human rights organizations that these interrogations are conducted by means of physical or psychological torture, and for sure of threats and inhumane and degrading treatment. What these colleagues said is that from the walls of the prison, they could hear the prisoners interrogated shouting "Sumud," so that the other prisoner could hear the scream. And the other prisoner, during the cross interrogations, was shouting back "Sumud." And when I see this word becoming a global word, uniting all of us, in this battle against the most extreme genocidal inhumanity, I thank you profoundly, because you are showing us that the Palestinian steadfastness is a gift for ourselves to reform our decaying democracies, to take back the power that corporate genocidal elites have stolen from us. And by doing so, reshaping international relations by regaining democratic control over the foreign policies of our nations, at least in terms of respect of our minimum legal duties under international law. Alongside this image of steadfastness and personally of enthusiasm of seeing so many European cities with dozens of thousands of people gathering to show their support for the boats of the flotilla, I have the duty to keep sharing the images of horror coming from Gaza. Yesterday, like every day in the last 700 days, I have seen one of the worst footages coming from the aftermath of an Israeli bombardment in Shujaiya on the Alaf and Aluk families. The children of these families, those that were the children of these families, were unrecognizable. Only pieces of their bodies remained, the upper torso without limbs, blended in the iron of their beds and in the rubble of their houses. So, with this level of unspeakable horrors every day for 2 years, what the SUMUD Flotilla is doing is giving us an example that we can peacefully take matters in our own hands and force action on our governments, betraying their mandates and our own constitution. Speaking of legal mandate, and here I go to the core of what I want to share with you legally, and then I leave the space to all those in presence that need to intervene. The prohibition of starvation as a method of warfare is one of the oldest prohibitions of modern laws of war. It's somehow interdependent and an essential articulation of the red line that modern international humanitarian law draws around all civilians and civilian objects to protect them from the effects of the hostilities. Obviously, you cannot starve an enemy without also starving the civilian population in its proximity. That's why not only starvation is prohibited as a method of warfare, but on any occupying power in the world, nowadays as well as in the future, there is a customary international law duty not only to remove any impediment to the passage of humanitarian supplies and relief, but to actively facilitate its arrival and distribution to the maximum extent possible and without any discrimination. That's what the Fourth Geneva Convention and the additional protocols say. Of course, these legal duties in the hands of Israel have become a mirage, a sad weapons of genocide denialism. Even just drops of aid have been transformed in mortal death traps managed by a dubious and at this point a genocidal organ, which is the so-called Gaza Humanitarian Foundation. It is inadmissible that the so-called distribution of aid is still in the hands of this rogue actor. I agree with what Hussein was saying, that the most important legal framework to be applied to the crews of the flotilla is human rights law. But somehow I want to add something about humanitarian law, because, you know, in all situations of armed conflict and occupations, even without a single bullet shot or armed conflicts under international humanitarian law, the ICJ has told us long time ago that human rights continue to apply. So the two legal frameworks are not necessarily mutually exclusive, in particular from the point of view of the protection of the civilian on the cruise. Hussein also said, asked me to say something about the right to innocent passage under UNCLOS, the Convention on the Law of the Sea. And you know, one of the paradoxes that we are facing is that the right of innocent passage is imposed on the coastal state, meaning the sovereign state of those territorial waters. So we shouldn't forget that Israel is not the territorial state of the Gaza waters, that its naval blockade is unlawful, as all the articulation of its unlawful occupation, as the ICJ told us unequivocally in July 2024, and that therefore they have no valid legal title to block these vessels, board them, or worse, as some of the Israeli regime terrorist ministers are threatening, detain them as terrorists. Willful deprival against protected persons of fair trial guarantees is a war crime under the Rome Statute of the ICC. And the same applies to the denial of humane treatment. So I want to conclude by saying that we need a step forward, even from scholars worldwide, in supporting the SUMUD Flotilla, and not only from scholars, even from networks of practitioners. We might be facing the eve of a serious crisis which could enable one of the greatest set of domestic and international litigation in recent legal history. In order to do so, we need to be as organized, as effective as our adversaries. And I think we could count on many forces which would help out of esteem, appreciation, and feeling represented by the global SUMUD. So, for the little I can, count 100% on me as well in this effort. Thanks so much for what you are doing, and we will continue to closely follow you step by step until you get to Gaza. I conclude by telling you what some Italian port worker say. They say that aid is from the people and belongs to the people of Gaza, and that if anything wrong is done against the boats or the crews, they will block everything, and not a single mail. And not a single name will go to Israel or come from Israel. And I think they need our support, and I hope that they can really realize what they are saying. So that's all from me. Thank you so much for the honor of being with you, and thanks to Heidi, to Penny, to Francesca, and thank you.
Thank you so much, Luigi. And just for everyone, I should have introduced Luis. He is associate professor in international law at the University of Molise in Italy. So thank you again for being with us. Bye bye.
Can I have them? Okay, Luigi, are you there?
Yes, I'm here.
Okay,
Yeah.
can we conclude on one question? Maybe for international lawyers, it is more easy, easier to grasp, but the natural inclination to think about blockade is that if Israel is occupying Gaza, since as an occupier, of course, it will have some discretion over its seas too. Yet, as we know, as an occupier, it can have some control over its territorial waters. Just like in the land, in the territory, this comes with lots of responsibilities in that territorial waters too. So since there is this control issue in the territorial water by the occupying power, which is Israel, can you elaborate on how it's different than this control from the blockade? Thank you very much.
Well, actually, I think that we can broadly speaking bring back the legal principles that should guide the naval blockade to legal principles that guide the law of the occupation around the world, which means that if there is an exercise of effective authorities over territory or over sea in which the state has no sovereign powers, these powers, this authority must be exercised in the interest of the population facing the consequences of this military control. So we are at an intersection of the two legal regimes, because once you have a customary duty to facilitate to the maximum extent possible the passage of humanitarian aid, and you have a right to innocent passage clearly defined by Article 19 of the UNCLOS. The maximum indulgence we can exercise toward Israel, and I don't think the case under the advisory opinion of GAZA is an inspection to the boats to verify that they do not transport weapons. That's the maximum we can concede. After having verified that there is no transportation of military objectives, there is only one thing that they should legally do. They should go back to their port. We know, of course, that this won't be the case. We know that every legal technicality will be misinterpreted, instrumentally invoked, as well as human shields, collateral damage, and the notion of military objective have been instrumentally invoked to legalize a genocide. And that's why we have to exercise maximum vigilance as scholars and as practitioners on the developments of the mission.
New panel now. Thank you for your contributions. See you until next time. Yeah.
Please, dear panelists, you are welcome. We are starting without a break, and after the first panel, we will make a break. I think middle is better. Yeah, I can sit here. Yeah, please. İkisini birden mi? İkisini birden. Tamam. During the presentation, we will need to use both microphones. One for our event and another one is for Al Jazeera. It is also for, we would like to, okay. Would you like to, excuse me? Yok, şu anda başlamadım. Aramızda konuşuyoruz. Ha. Would you like to do the presentation here or by sitting? If it's the case, I will leave this microphone there. Gaza and to challenge the blockade that blocks the most essential goods from them. This need could not be more urgent because, as several public and private international institutions have confirmed, Gaza is now, actually for a while, facing a human-made famine, very severe famine. More than 335,000 children under 5 are at risk of dying from hunger. Water has almost disappeared. Hospitals are destroyed. Hence, the life expectancy has completely collapsed. And we need to acknowledge that this is not only an humanitarian emergency. This is also an emergency call for international law. The International Court of Justice has already, and for a long while ago, ordered Israel to allow basic services and aid into Gaza. Yet, Israel has simply failed to comply with this order, as many other governments simply failed in their duty of preventing Israel with their continuing support. And when the states, which are the main pillars of the international community, have failed in taking sufficient action, another component of the international community felt compelled to step in, which is the transnational civil society. The global SUMUD Flotilla is one such act. It is a last resort to protect life. This flotilla sails lawfully against an unlawful blockade, and its participants are civilians, non-combatant civilians, who are completely under the protection, must be under the protection of the international humanitarian law. So any attack or violent interference with them would be completely illegal. Today, we are joined by actually three now, because Luigi Daniele has completed his speech, three outstanding scholars who will guide us through the legal dimensions, different legal dimensions of this mission. Professor Penny Green, a professor of law at Queen Mary University of London, and also a member of the Gaza Tribunal. She will speak on the power of the civil resistance and the Sarajevo Declaration of the Gaza Tribunal. Dr. Polona Florijancic, an independent researcher on international criminal and human rights law. She will examine the international ICC's approach to the attacks on the past humanitarian fleets to assess how they may respond if the fleet, if the SUMUD flotilla were attacked by Israel. Hopefully not, but we need to discuss this reality as well. Dr. Beheshti Aydoğan, an international law scholar at Boğaziçi University, he will explain the responsibility of states to protect this flotilla amid the ongoing genocide in Gaza. Thanks to all of these special experts for their participation. We'll move on in the same order as I presented their names. Kindly, every speaker has 15 minutes, and hopefully we will have 15 minutes of Q&A session at the end. So we can begin with Professor Green. Thanks a lot again. I think this works.
Is this working? You can all hear me? Great, thank you. Thank you very much. And it's a huge honor to be here amongst so many brave and courageous activists. It feels a very special moment here in Tunisia. And I want to thank the Global SUMUD Flotilla, the WALAS organizers, and the Tunisian Bar Association for making this event possible, and for inviting me as a representative of the Gaza Tribunal. If I were a sailor and perhaps a little more courageous than I am, I would be joining you on a boat. But just being here, surrounded by and uplifted by the activists that I've met so far, feels like the most enormous privilege and a moment of joy, as Francesca mentioned, a moment of joy in an otherwise desperately bleak global landscape. Thank you all for your bravery, your spirit, and your humanity. The world has arrived at a very dangerous precipice. Gaza has exposed the fissures and fractures that so glaringly divide our capitalist world. It's revealed in raw brutality the gaping chasm between persecutors and persecuted, between oppressors and the oppressed, between the colonized and the colonizers, between the rich and the poor. And in doing so, Palestine has become the lightning rod for the global anti-colonial movement, for an awakening and recognition that change must come from below, must come from a newly animated civil society. My brief remarks relate to civil society law and challenging state crime, of which genocide is clearly one. As I said, I'm here representing the Gaza People's Tribunal, which stands in solidarity with the people of Palestine and the courageous people of the SUMUD Flotilla. But I'm also here not as a lawyer, but as a critical scholar of state crime and as an activist. Deploying law strategically, as the wonderful Hind Rajab Foundation do in their pursuit of holidaying Israeli genocidaire, and South Africa's case against Israel at the ICJ, can all play a powerful role in the civil resistance against genocide. But imagining that the international legal order through the international courts can play anything more than a symbolic role in the struggle, I think, is deeply misguided. With respect to Palestine, Israel has breached over 30 UN Security Council resolutions without consequence, and its daily egregious international crimes have led to nothing but impunity. Israel's ongoing genocide reflects the abject failures of the UN system to prevent and punish war crimes, crimes against humanity, and genocide. And as a scholar of state crime, I can't rely on legal definitions, given that states make laws and are notoriously unwilling to define their own actions and behaviors as criminal. And so my colleague Tony Ward and I came up with what we think is a much more powerful and useful definition of state crime in which genocide features, and that is human rights violations perpetrated by state agents in pursuit of state organizational goals. For a scholar of state crime, the solutions to state crime lie well outside the frameworks of criminal justice, law, international conventions, and international courts. Instead, any such solutions are much more likely to be found in the struggles of the state's victims, or with those who advocate and organize as allies on behalf of those victims. And it's the organization of those victims and allies that not only has the power to challenge state violence, but is absolutely central in first defining and naming that violence as criminal in the first instance. Civil society has proven itself to be a much more effective force than international law in first identifying, gathering, and analyzing evidence, and naming and resisting the worst crimes of states, particularly through campaigns of civil disobedience, mass strikes, and boycott, divestment, and sanctions, and the kind of actions that the SUMUD Flotilla represents. Civil society enjoys widespread legitimacy as an authoritative check on the power and actions of the state. Because it operates from the ground up, it has far greater agility and capacity to recognize the processes involved in earlier stages of state crime. Genocide is not a singular, spectacularized event of violence. It's a process. It begins with structural strategies of dehumanization. It bleeds into sporadic acts of litmus testing violence against the target population. And that violence in itself can lead to isolation, ghettoization. And once that isolation takes place, it's much easier, as we've seen in the case of Gaza, to systematically weaken the population within that ghetto, within that isolated space. And once a population is weakened and isolated, then we see the annihilation phase, if we reach that phase. It's not the end. The annihilation phase is never the end of genocide. We then have a reorganization of the state which has perpetrated genocide in the absence of the people who've been erased. Why do we know about Israel's genocidal crimes? Not because our media reports on them or our governments denounce them. To the contrary, our mass media and our governments have been central in sustaining and perpetuating these crimes. We know about Israel's crimes only because for decades, Palestinian and other civil society groups globally have been documenting them, analyzing them, and reporting on them. The Israeli crimes embodied in all the stages of genocide that I mentioned have been extremely well documented by international human rights groups, by Palestinians, by independent journalists and scholars. And these crimes include the settlement movement, routine settler and IOF violence in the West Bank and East Jerusalem, house demolitions, village destruction in the Negev, forced evictions, the detention without charge of thousands of Palestinians, including many children, the apartheid structures of walls, roads, and checkpoints, which make Palestinian daily lives in the West Bank an absolute misery, discriminatory laws and the process of Judaization, not to mention the 16-year siege of Gaza, which preceded the nightmare which has followed October the 7th, 2023. Civil society has been at the heart and center of all evidence gathering in relation to Israel's crimes. And this work by civil society has led efforts to successfully name Israel's crimes as settler colonialism, as apartheid, and as genocide. The Gaza People's Tribunal is a people's tribunal in the tradition of Bertrand Russell's International War Crimes Tribunal for Vietnam and the Rome-based Permanent People's Tribunal, which grew out of it. Unlike a court of law, our tribunal, the Gaza Tribunal, begins from the premise that Israel is committing genocide, that it is a settler colonial apartheid state, underpinned by the racist ideology of Zionism. We do not require a ruling of an international court to determine that a genocide is happening and has been happening in its early stages since 1917 and the Balfour Declaration. Thousands of civil society organizations, historians, criminologists, international lawyers all agree that it is genocide. The Gaza Tribunal project, running parallel to the existing legal procedures that you all know about in the international courts, is led by Professor Richard Falk And its primary aims are to essentially invigorate the power of civil society in its efforts to stop the genocide and to promote solidarity among Palestinian and global civil society activists and organizations, progressive intellectuals, and people of conscience around the world. And it's based on witness and expert testimony to create an archive of both the historical and geopolitical contexts of the genocide and the solidarity movement which it has engendered. We start from a recognition that governments and the international legal order have not simply failed the Palestinians, but they've actively enabled Israel's impunity and its decades-long colonial persecution of the people of Palestine. We are not a legal tribunal. Rather, we seek to document and give voice to Palestinian witnesses and to the movement of solidarity that has grown up around supporting the Palestinian people. For us, the challenge of justice and resistance falls to civil society, to acts of solidarity like the SUMUD Flotilla, to social movements and to people of conscience everywhere. We understand the need to mobilize the power of the people in their millions to challenge the crimes of the Israeli regime and its co-conspirators, our own governments in the US, Europe, and elsewhere. The tribunal seeks to counter the forces of evil with the forces of justice by bringing pressure to bear in every sector and making clear that genocide will not be normalized, that apartheid will not be normalized, that colonialism will not be normalized, that Israel and its Zionist underpinnings will not be normalized. We know that Israel's Zionist regime is committed to seeing out this horrendous genocide. And we know that its principal genocidal partner, the United States government, is equally committed to this genocide and to the erasure of Palestine. At the same time, we know that other Western governments like the UK and Germany and complicit Arab states have fully endorsed Israeli impunity and continue to do so. So the question is, how, in the face of such powerful forces of carnage, do we stop a genocide? How do we dismantle the Zionist state and those global powers whose ultimate goal is the erasure of Palestine, knowing that law and its international mechanisms are not the whole answer, or not very much of the answer at all? The tribunal is clear. Genocide and the settler colonial apartheid regime which has facilitated it will only end through resistance against the regime. The steadfastness of the Palestinian people, the solidarity of the rest of the world, and the isolation, weakening, defeat, and dismantling of the Israeli regime and the global political and economic structures that support it. The flotilla, in its essence, is a marvelous example, and we very much hope that it is able to break the blockade. At the first session of the Gazan People's Tribunal held in Sarajevo in May of this year, the contextual foundations for understanding Israel's genocide were laid. Over the course of 4 days, we heard expert testimony on the history of the genocide, on the crimes that Israel has and its partners have committed, and on the geopolitics fueling the genocide. Like Bertrand Russell before us, and I quote him here, "Our task is to make mankind bear witness to these terrible crimes and to unite humanity on the side of justice." The Sarajevo Declaration, as we called it, was the culmination of the work of the tribunal to date, and you can find it on the Gaza Tribunal's website. It was a rallying cry. It embodied the demand for an immediate withdrawal of Israeli forces and an end to the genocide, to all military action by Israel, to force an end to forced displacement and expulsions, an end to settlement activities, an end to the siege of Gaza, and restrictions on movement in the West Bank. It calls for the immediate and unconditional release of all Palestinian prisoners, including the thousands of Palestinian women, men, and children held in abusive Israeli detention regimes. It insists on the immediate resumption of massive humanitarian aid to all of Gaza without restriction and interference, including food, water, shelter, medical supplies and equipment, sanitary equipment, rescue equipment, and construction materials. It also calls for a complete withdrawal of all Israeli forces from Lebanese and Syrian territory. The Sarajevo Declaration recognizes that dangerous forces in both the public and private spheres are pushing us towards the abyss. The events of the past 23 months and the tribunal's own deliberations have convinced us that both key international organizations and most countries in the world, whether acting individually or collectively, have not only failed in defending the human rights of the Palestinian people and in responding to the Israeli regime's genocide in Palestine, but as I mentioned earlier, have in varying degrees been complicit in these crimes and have certainly contributed to Israel's impunity. In the declaration, amongst other things, we denounce the wave of persecution against human rights defenders, peace activists, students, academics, workers, professionals, and we honor those, like those who are participating in the flotilla, who despite this persecution have had the courage and moral conviction to stand up and speak out while rejecting the tactics of smearing us as anti-Semites or supporters of terrorism, and to all those who dare to speak up against the Israeli regime. We also reject the destructive ideology of Zionism as the official state ideology of Israel, of the forces that colonized Palestine and established the Israeli state on its ruins, and of pro-Israeli organizations and their proxies today. We demand immediate action to isolate, contain, and hold accountable the Israeli regime through universal boycott, divestment, and sanctions, a military embargo, suspension from international organizations, and the prosecution of its perpetrators. The Sarajevo Declaration ends with the following: the challenge of justice now falls to the people of conscience everywhere, to civil society and to social movements, to all of us. Palestinian lives are at stake. The international moral and legal order is at stake. We must not fail. We must not relent. Millions of people continue to march in cities around the world. Civil resistance groups non-violently target armaments factories that supply weapons to Israel. Trade unions have begun to block armament shipments to Israel. The BDS, particularly through its academic and cultural boycotts, has grown in power and impact. And a phenomenal, I don't know if this figure is right, but 26,000 at least, that was the last figure I saw, have signed up for the SUMUD Flotilla. Joy, as Francesca was saying, she stole the words from me, but joy is something we tend to share only privately in these dark times. But the flotilla is a real cause for public joy because it reminds us of our collective power and of the fact that humanity lives strong amongst ordinary people of conscience. And I'd like to conclude with another quote from Bertrand Russell. In his closing address to the final session of the Vietnam War Crimes Tribunal, he declared in words that equally impel our resistance today. He was speaking about the Vietnamese, but it applies so aptly to the Palestinians. He said, "The napalm and pellet bombs, the systematic destruction of a heroic people, are a barbarous rehearsal. The starving and the suffering will no longer die in silence. We must discredit the arrogant demand that they protect our comfort with their quiet agony." Thank you.
Thanks a lot, Professor, for your powerful speech and great timing as well. Now the floor is yours, Dr. Polona Floriancic. Thanks.
I will try to be very quick. In 2010, the Freedom Flotilla came under attack by the IDF. On the Mavi Marmara, 10 people were killed, execution style, most of them, in the head at close range, in the back, and 2 before the soldiers even boarded the boat. But 55 people were injured, and there were hundreds of instances of outrages upon personal dignity, both on board and once on Israeli territory when the detainees were forcibly transferred there. Today, I want to talk about the regrettable decision of the prosecutor of the International Criminal Court not to open an investigation into the raid, and I want to draw implications for a potential case being brought before the ICC today if, God forbid, war crimes were to be committed against the passengers of the SUMUD Flotilla. This is especially important for those sailing under the flags of state parties, such as Tunisia. I actually don't know how many of the boats are sailing under ICC state party flags, but for all of them, that's the most important thing. But first, I want to give a quick background on the prosecutorial discretion at the ICC and on the struggle of Palestinians to even bring Israeli crimes under the jurisdiction of the court. The discretion of the prosecutor in which cases and situations they choose to pursue is the cause of most of the controversy surrounding the court. And it's more than a mere impression that the court stays away from tackling the West and until very recently Israel. Palestine has had to fight a long battle to be recognized as a member. In other words, to be granted the same access to international criminal justice as other peoples. From my point of view, this is another way in which the Palestinians have been dehumanized. The denial of their statehood has meant the denial of recourse to justice. They already in 2009 tried to get jurisdiction, but were not able. In April 2015, they finally became a state party, and with jurisdiction over Israeli and, of course, Palestinian crimes since June 2014 on their territory. Following a nearly 5-year preliminary inquiry and more questioning of the court's jurisdiction over Palestinian territory, it was not until 6 years later, in March 2021, that a formal investigation was finally opened for crimes committed since June 2014. The first arrest warrants didn't happen until last year, as we all know, but those only relate to crimes since 8th of October 2023. And also disregarding essential lines of inquiry, such as the question of illegal settlements. To sum up, 20 years ago, Palestine sought to have jurisdiction since 20 years ago, and they only really got it recently. So 20 years of criminality has been successfully, liability has been successfully avoided. Now, when it comes to the 2010 flotilla, the referral to the court did not come, of course, from Palestine, but Comoros, since the Mavi Marmara was sailing under the Comoros flag. As with any referral, the prosecutor had to conduct a preliminary examination of jurisdiction and admissibility, and in 2014, she closed the case, saying that there was insufficient gravity to open an investigation. Crucially, though, the prosecutor did find a reasonable basis to believe that war crimes had been committed. It was just a matter of insufficient gravity. This was the first time that the prosecutor decided not to proceed with an investigation after receiving a referral. Always before that, they would. But it was also the first time that the pretrial chamber used its power to review this decision. And it disagreed with all parts of the analysis on every point with the prosecutor. The core of the prosecution's reasoning was that the number of victims was too low compared to other cases investigated. And also that it didn't have a significant impact since the supplies which were carried with the boats were eventually distributed in Gaza. In challenging the prosecutor's assessment, parallels were inevitably drawn with the case of Abu Garda, this is from Sudan, where merely 12 peacekeepers and 8 others were killed and 8 others were wounded, but the gravity there was found to be sufficient because, quote, it seriously impacted the broader community. The prosecutor, however, drew a distinction between peacekeepers and human rights activists, putting more weight on the first. They stated that attacks against peacekeepers are attacks directed against the international community as a whole and strike at the very heart of the international legal system. Thus, they constitute crimes of exceptionally serious gravity, which are directed at people who risk their lives to protect the international community's fundamental interest in maintaining the international peace and security of mankind. The prosecution also said that after this attack, the peacekeepers reduced their activities in the area, impacting the area or the protection that the people in the area were receiving. On the other hand, the prosecutor denied the purely humanitarian mission of the Freedom Flotilla and said that the victims were, quote, neither peacekeepers nor humanitarian assistant workers due to their, quote, apparent lack of neutrality and impartiality as evidenced in the flotilla's explicit political objectives and apparent primary purpose of challenging the blockade and raising publicity for this cause. Also, the failure to obtain Israeli consent and refusal to cooperate with the Israeli authorities in their proposals for alternative modes of distribution. In other words, what was held against the flotilla was the fact that it sought to contribute to an end of the illegal blockade itself, that is substantially alleviating the suffering of the population of Gaza, not just to bring some momentary relief. Now, if we apply this to today's mission, I hope it will be clear that no one has to cooperate with the genocidal state in how to deliver aid, that we have the right to deliver it without their permission. They're an illegal occupier imposing an illegal blockade and committing genocide using the blockade to block entirely any food for the Palestinians. Also, what hopefully will be taken into account that the SUMUD flotilla's aim is entirely humanitarian in the sense that it seeks to establish a humanitarian corridor. So in terms of the pretrial chamber, it disagreed on the lack of substantial impact, saying that the incident sparked international concern, and also that it sent a clear and strong message to the people of Gaza and beyond, that the blockade was in full force and that even delivery of humanitarian aid would be controlled and supervised by the Israeli authorities. Nowadays, we know that it goes well beyond controlled and supervised. It is being effectively blocked as a part of the genocide. Also, the fact that the aid from the Mavi Marmara was eventually distributed does not negate the most important impact of these crimes, which was the intentionally created climate of fear aimed at dissuading anyone else from attempting another flotilla or indeed any kind of assistance to the Palestinians. Through a display of brazen disregard by the IDF for human life and human dignity, not just when it comes to the Palestinians, but for anyone, regardless of passport, regardless of jurisdiction. In fact, the impact in this regard is immense. The fact that there are still thousands of people who are willing to risk their lives to break the siege does not negate this impact, because if this impact was not there, we would be in the millions. But we are cowards. So the people on these boats and the people who applied are the most courageous people, and really I bow to you. Thank you. The gravity should have also been evaluated at the time in the context of other murders of activists, such as those of Rachel Corrie, James Henry Miller, and Tom Herndl, all of which took place well before the incident on the flotilla. There is a clear policy of scaring people away from standing in solidarity with Palestine. After the flotilla incident, other international activists, such as Ashainur Ezgi, I hope I did that one, have been killed. The attacks on subsequent flotillas further prove that Israel, very much as a policy, wishes to keep this fear alive. In May, the Conscience was attacked by drones in international waters 17 nautical miles from off the coast of Malta, nowhere near Israel. In June, the Madeleine was forcibly intercepted, attacked with a chemical spray, aborted, and the volunteers illegally detained. A motion signed by 49 UK members of parliament on this occasion rightly noted that Israel's threats and attacks against humanitarian missions like the Madeleine, carrying essential aid, and attacks against the international human rights defenders on a broader pattern of impunity and disregard for international norms. I would like to add here that showing off this impunity is part of the raison d'etre of these attacks. In a normal world, Israel would lose less by allowing baby formula and other essential aid in than by attacking such missions. But in our world, it is the contrary. Israel gains with the perception of untouchability. With each such attack and the signal to others that assistance to Palestine is too costly and too impossible to be worth trying. If a similar attack was to happen on the flotilla now, one would hope that the assessment of gravity would also take into account the context of not just the genocide and the man-made famine, and let's not forget that the warrants at the ICC are also for starvation as a weapon of war. One would hope that an assessment would take into account also the banning of UNRWA and the killing of 360 employees of UNRWA, the attacks on other aid workers such as the World Central Kitchen Convoy, killing 7 aid workers, as well as the massacres which occur daily at the killing machine, soon to be concentration camp, with the Orwellian name of Gaza Humanitarian Foundation. What should also be taken into account is the complete abandonment of the Palestinian people by the majority of world governments, including those that talk the talk, but do not take a single step to walk the walk. In other words, the abject failure of the so-called international community to protect these people, and the fact that civil society has had to step in to fill the gap left by the international community, just as Wael was explaining this morning. For all the above, attacks on human rights defenders who are willing to put their lives at risk in these circumstances should be attributed the same gravity, if not more gravity, than attacks on peacekeepers. In this context, it is not just an attack on the so-called international community, but on humanity itself. Apart from denying sufficient impact, the prosecutor also downplayed the gravity by essentially interpreting the incidents as a series of unrelated crimes, without an existence of a plan or policy or any involvement of senior IDF commanders and Israeli leaders, despite vast evidence to the contrary. This was essentially pretending that there's a few bad apples in the IDF, just acting out unrelated, and this is nothing of particular gravity. The unlinking of different stages of criminality furthermore served the claim that the ICC lacked jurisdiction over what the Human Rights Council described as detainees systematically being subjected to extreme brutality once on Israeli soil. This supposed lack of jurisdiction also impacted the assessment of gravity. This last point was particularly problematic, and Comoros rightly raised an issue with it, stating that the prosecutor's stance was, quote, in direct contradiction not only with the notion of continuing crime, but especially with the prosecutor's own argument in the case of Myanmar and Bangladesh, where she found that the conduct requirement for ICC jurisdiction is that it is sufficient that at least one legal element of a crime under the statute must occur on the territory of a state party. In the case of Myanmar and Bangladesh, it was the question of persons being deported from the territory of a non-state party into the territory of a state party. And this was considered one crime, and this was considered enough to establish the so-called jurisdictional hook to allow the ICC to have jurisdiction over it. On the contrary, when it came to the Mavi Marmara, some crimes were completed entirely on board, whilst others entirely on Israeli soil by other perpetrators. And the prosecutor said here, the perpetrators were only connected by serving the Israeli army, and there was no other connection. This kind of interpretation basically means that Israel can kidnap any one of us from ICC member states' territories, and whilst they bring us to their territory, they can do whatever they want. The jurisdiction will no longer apply. I would like to see if the ICC would have the same opinion if this was Russia and the kids which were supposedly kidnapped from Ukraine. I don't know if they were, but because everything is political. But let's say, for argument's sake, they were kidnapped and now they are abused in Russia. Would the ICC also say, oh, but this is on a non-member state party territory, so we no longer look at that? I doubt it. 5 minutes, I will finish, don't worry. Yes, Myanmar and Bangladesh was different, but particularly in the sense that the criminality started on the territory of a non-member state. Here we are talking about starting on the territory of a member state, and then individuals forcibly transferred to a non-member state to be further abused there within the context of a continuous unlawful detention. Whether the victims were passed from one abuser to the other shouldn't be a determining factor. And the prosecution was furthermore wrong in downplaying the nexus between them in the sense that they were merely all served the Israeli government. If abusive and criminal behavior coupled with complete impunity is so widespread within army personnel as it is in the IDF, this in itself shows a policy of such behavior and a link between individual incidents. We have now all witnessed how the IDF systematically and as a matter of policy murders, rapes, kidnaps, commits all sorts of other war crimes and crimes against humanity in broad daylight. And we also know from many soldiers' testimonies that they're perpetrating the abuse in order to create fear in the Palestinian population as part of the essence of serving in the IDF. The attacks on international human rights defenders are not unconnected, but rather part of the same mission. In other words, the IDF, together with the Israeli government, is a joint criminal enterprise with the criminal aim of ethnic cleansing for the sake of greater Israel. Now back to the Mavi Marmara. Despite the pretrial chamber disagreeing with the prosecutor, she refused to change her stance. And the matter was finally closed in 2020. What did change in between, however, was that the prosecutor declared the opening of the investigation into Palestine. At the time, the prosecutor bizarrely suggested that because she opened the investigation, her decision in the flotilla situation should no longer be questioned. On the contrary, and rightly, Comoros observed that the opening of the investigation should actually bring more weight to the entire case, because now the entire genocide is part of your mission as well. This was not taken into account at that time, but now you could make the same argument and it will hold even more weight. Now to conclude, I conclude. The unfortunate or sad or tragic reality is that the discretion of the prosecutor in any future incidents will be determined by policy considerations. If it wishes to, it can find gravity and even jurisdiction easily. If it wishes not to find it, it will not find it. And that is unfortunately the reality. Thank you very much.
Thanks. It's really valuable that you examined this topic, which is a significant historical precedent for the upcoming flotilla, even though we wholeheartedly hope that the trajectory of the flotilla will not be comparable. Now it's Dr. Beheshti Aydoğan. The floor is yours. We can invite you here. Thanks.
Hello. I want to thank the organizers, the Tunisian Bar, Bolas, and I also would like to begin by thanking to those who are here in Tunisia to be on board the ships. I think a special thanks go to them. So I'll try to explain the connection between the responsibility of other actors and in the context of flotilla and its protection. And so what we have in international law is we have like 3 different subjects of international law essentially. And those actors are individuals, states, international organizations, and you can think of international organizations as more of a general category, which also include the non-state actors as well in a way. But what we see here in the flotilla mission is you see individuals taking proactive action. So what's missing is those other actors are missing here. And I think it's sort of like interesting to sort of speak about protection by others of the flotilla, given the proactive mission taken by individuals themselves. So we only have individuals actually taking action here and expecting something from other subjects of international law, taking the role of an actor So instead of being a sort of like a subject of international merely, they're becoming more of a sort of actor. So what's the sort of what's the reason? What's the sort of and I think our sort of emancipatory potential within those and international organizations, they still carry some emancipatory potential within themselves, even in this context. So that's the reason we sort of speak about the responsibility of other actors, other subjects of international law in the context of flotilla. That's as far as I can sort of provide some form of meaning to the reason behind searching for the responsibility of these different actors. So what we see with the SUMUD flotilla mission here, so they're as far as I can see, they're four main premises here. And the idea is to have immediate and continuous humanitarian corridor and give access to life-saving aid without obstruction and delay. Peaceful humanitarian non-violent initiative, that's the sort of one of the main premises of the flotilla here. And we also have the idea that, okay, we need to tell states that international humanitarian law oblige them to protect civilians in conflict zones and to allow the delivery of humanitarian assistance. And as many, and some of our speakers mentioned that they are sort of kind of obliged to streamline the relief action here in a sense. So these are the sort of the aims of flotilla. And how do we connect these aims with the responsibility of others, responsibility of states? So my main connection point is if we look at the sort of the last year's opinion by the ICJ, what we see, if we can establish the connection from the point from the conception of famine in here, and what we're seeing in the decision of the ICJ in the opinion, we see three main elements that ICJ thinks states are responsible, they are sort of consider. So one theme is illegal occupation. So states should not recognize the illegal occupation, the situation created by Israel, and they should not recognize it as legal. That's one of the sort of key things. And there's another element which is not to render aid or assistance to this particular illegal situation in the occupied territories. And the second theme is, in the opinion, is self-determination. And ICJ has quite a strong wording when it comes to self-determination in the context of Palestine. And interestingly, it does mention in its both opinions that states should remove the impediments against Palestinian self-determination. So they indicate some form of proactive actions, not only some sort of refraining position. It requires you to take some form of action in that sense. And it does also mention as a third theme, what you also have is the humanitarian compliance. It wants states to make sure that Israel complies with international humanitarian law. So our point of entrance here is, again, is the violation is Israel is mainly accused. What it does actually in Palestine, you see Israel starvation as a method of warfare. That's the key violation here. The state should make sure that Israel should not use starvation as a method of warfare. That's one of the sort of key roles that states should take on in that sense. So that's the sort of the basis of establishing responsibility of other actors of international law in that sense. So it's sort of like a chain of reasoning. If you think about it as like a chain of reasoning, what you have is you have an illegal occupation, and you have an illegal or unlawful blockade. You have starvation, and you have famine, which again leads to genocide, among other reasons. Obviously, there's a material destruction, there's continuous killing as part of that, but famine is one of them essentially. And what flotilla stands here is, it stands for humanitarian passage, humanitarian aid. So that's what it does to prevent the situation created by Israel. Israel's sort of like barbaric actions. So that's the sort of like the connection that I can establish in the sense of the relationship between what Flotilla does and what others should do as form of their responsibilities. And I also want to mention like one key thing here. So we hear a lot of sort of like non-recognition, duty of non-recognition, but it generally it is sort of like seen as a sort of like a form of negative measure, like not doing something. But if you actually read the decision, read the opinion, and what you all can also see, as far as member states of the UN concerned, the ICJ says, so it sort of like frames non-recognition, the duty of non-recognition, as a form of proactive measure in the context of sort of like trade and investment. So the court says Israel, in the territory of the State of Israel and the Palestine territory occupied since 1967, the court considers that the duty of distinguishing dealings with Israel between its own territory and the occupied Palestinian territory encompasses, inter alia, the obligation to take steps to prevent trade and investment relations that assist in the maintenance of the illegal situation created by Israel in the occupied Palestinian territory. So as far as court frames it, there is a proactive obligation on the part of member states of the United Nations to take steps. So you have to do something. Not only you should avoid doing something, you should do a positive action. You should take a positive and proactive action here. So what we see in the opinion, and there's a lot of sort of proactive measures in the form of responsibility which could be taken by states. And that also sort of like, so that the idea of responsibility here entails international organizations as well. So what court does is it indicates that the precise modalities of doing something in the context of the illegal occupation and blockade in Palestine, they should be determined by international organizations. And in this context, it does mention the General Assembly, it does mention the Security Council. So it indicates that these actors are actually sort of under obligation to do something, and they need to determine the precise measures that need to be taken to sort of achieve Palestinian sort of like self-determination, to remove any impediment towards that end. And so if sort of like in particular, if you want to think what we can expect in sort of like in this present context, what I understand is like, so what we see is we see a case of famine, and what we're doing is we're delivering some form of aid. So in my understanding, in a sense, this is the minimum that we need to do for Palestinian liberation. So this is the sort of the least amount of work that we need to do. That's the sort of like the lowest point during the sort of like the Palestinian sort of during the course of the Palestinian liberation in that sense. So preventing famine is the minimum we need to do. And to that end, we see like within this sort of structural context, and that both international organizations, states, even though they are not the most sort of like active actors in the context of Palestine here, they should sort of like take more proactive action to this end. That's the sort of like the least form of sort of action we can expect from them. And I think we also need to sort of like keep the legal narrative like kind of like an alive in the sense. So reiterate the illegality of the occupation, reiterate the illegality of the blockade, like constantly. Do not sort of like avoid, sort of refrain from that in that sense. And we have like additional protocol parties. They're under obligation to sort of refrain and facilitate rapid and unimpeded passage of these ships in the context of delivering aid to Gaza. And we also have coastal countries sort of, they're under obligation to refrain from preventing innocent passage. That's one of the particular obligations which is quite relevant in the context of the flotilla. You also have flag states. They need to exercise their right of sort of diplomatic protection in case anything happens. and they also need to protect their own citizens' human rights. And what we also can say is, I think one of the key things was that there was sort of like a possibility of sort of inspection by the Israeli probably Navy, and I think as we discussed before, and we probably need to expect the United Nations to take part at least sort of on within that sort of like if it happens, if those kind of like a case of inspection does happen. And we need to expect United Nations take some role within that process, at least to sort of make sure that we are sort of like getting out of the right information to the world in that sense. We do expect a lot sort of more from like organizations in terms of sort of like streamlining the Palestinian liberation, especially Palestinian self-determination in a sense. Expelling Israel is a possibility. It's not like it's not procedurally easy. I think there's one more option in terms of sort of like credential committee might take action in the sense that the UN General Assembly could take action to sort of not recognize Israeli credentials in a year, which is not necessarily easy, but I think that's also sort of like an option to sort of like consider. So I think these are the sort of like the practical like obligations that we can sort of attach to other actors of international law in the context of flotilla. But as I said, like the connection is apparent in the sense that we have famine as a point of connection, and we can easily establish the sort of like the basis of responsibility of other actors in that sense. And I want to sort of conclude with sort of like with a brief statement in the sense that breaking an illegal blockade is perfectly lawful. It will only be an honor to play a role in the liberation of Palestine. Palestine must be freed from the Zionist fever dream. Thank you.
Just out of Thanks a lot for your also thanks a lot for finishing earlier. You did not use your quota. Okay, we would like to have an extensive Q&A session, but it's not possible for us because we got late and we need to move to the other session. But just we will give a chance for a couple of questions, and please try to keep your question as concise as possible. Try to avoid giving a commentary, and also please mention the name to whom you are referring your question to. Okay, there is 1 and 2. Okay.
Thank you.
We put quota for a couple of questions, unfortunately, due to the time restrictions. Yes.
My name is Sahar. I'm an academic from Tunisia. My question is actually to all of you. International law does not prohibit occupation, particularly under international humanitarian law, but it regulates it. So are there any initiative or potential treaties to completely prohibit occupation under all forms? If not, what are the steps needed by international lawyers to make such treaty possible? Thank you.
Thanks. And we can collect a second question and then microphone. It's coming. Yeah.
شكرا. محمد رضا البقلوطي مدير تحرير الصحيفة.
لحظة.
Thank you. Can you hear me? Can you hear me, ma'am? Can you hear me? All right. Thank you. But translation is available. I'm sorry. Translation is available here.
Translation is available.
Mohammed Rida Al-Baqloti, the editor-in-chief of Lahza Bilahza. I want to make a suggestion. The Palestinian cause is an international cause.
والدولي باعتبارها قضية إنسانية بالدرجة الأولى.
It is a humanitarian cause, so supporting the cause is a priority. And the contribution of the civil society is the basic way of doing this. The flotilla is an incredible opportunity to reach the goal, which is breaking the blockade. I think that it is important that we continue such initiatives and to broaden the scope of such initiatives so that we can spread awareness among the public, which is the only way to achieve our goals. The role of the media is very important, and notwithstanding the genocide targeting the journalists, we should stand as one man in order to break the blockade and to uphold liberty and freedom. We need to ensure that humanitarian aid gets to Gaza, pending other bold and brave initiatives. Thank you for your presence and for your support. This is the only way for a better future for Palestine. Thank you.
Me to translate, or shall I keep it for the interpreters? Interpreters would like to.
I believe that, Professor, we can answer the question first, and then we can move to
I can just say it in 1 second.
Okay.
In one
Okay.
second. In
Okay,
1
then
second.
if it will be a summary.
First of all, he acknowledged all these efforts, by Flotilla people, and his suggestion that also we have to keep on this initiatives, and also he pressed on the public awareness that people should know through social media of what being done here. To be honest, even me in the United Kingdom, I didn't know a lot about Flotilla till I was invited. So again, he says, yes, we have to use the social media to raise awareness of what happened in Palestine, and also what happened here, especially if the governments or all the governments not doing their job. So people should be aware about what's going on. Thank you very much.
Shukran jazilan, and thanks, Professor. Then we can answer the question asked, but even though the guest asked to all speakers, we can choose one. Is there any candidate? Okay. The natural direction comes to you, doctor. Please, you can use it.
I think like the occupation is already sort of quite constrained. Like there's temporary limitations. It needs to be temporary. It needs to protect people in that area. So there's already sort of like regulations in place. And I think Israeli occupation is already illegal in that sense. I don't think practically we don't necessarily need something to sort of like do something else to sort of explain the illegality of it. So it's already an illegal occupation in that sense. One of the prevalent illegal occupations. And I see there's already sort of like enough constraints, which makes it illegal anyways.
Okay, thanks. Really, due to time restrictions, it's better to wrap up. I hope our audience will show understanding for us. We cannot receive more questions, so we will have a very short break for 10 minutes, right? For 10 minutes, and after the refreshment for the second panel, you are invited. Thanks for your participation, and thanks for amazing speakers.
significant and important.
We have a panel of 4 speakers. We're going to try and keep it brief so we can get your questions in. We are starting off, I'm going to introduce each speaker as they come in to speak. And just to say that Hussein's just having a break, and he's done a fantastic work with the rest of the team in organizing this seminar. We're first starting off with Joe Bluin. Have I pronounced that correctly? Okay, thank you. And I understand that you are an academic, a writer, and an activist, focusing on colonialism, race, gender, capital, and the international law of genocide. I understand that you have submitted a PhD to the London School of Economics on the norm of colonial impunity from Nuremberg to The Hague. You're based in around Johannesburg, and on Palestine, you organize with South African Jews for a free Palestine, which is absolutely fantastic. BDS, SA, and energy embargo. You please have the microphone. Thank you.
There we go. Sorry. Good afternoon, comrades, friends, colleagues. I'm really honored to be here today and to think with such brilliant people. I'm particularly grateful to the Tunisian Bar Association, to WOLAS, the Global SUMUD Flotilla, and the Gaza Tribunal for facilitating this gathering. I'm grateful to the participants of the flotilla who remind us, as Professor Penny Green just did, that the groundswell of popular resistance is more powerful than any law. Most of all, I'm grateful to the people of Palestine for reminding us what it means to be human in a world on fire and what it means to be brave in a world of barbarism. This presentation is something of a haunted and fragmented history of the colonial blockade and its interface with Zionism and other projects of colonial genocide, racial capitalism, annihilatory fascism, imperialism, settler colonialism, and death-making. Given that we gather on the eve of the historic departure of the Global SUMUD Flotilla from Tunis, sorry, I just need to put this down, there we go. I want to think with the sea and the aquatic archive alongside what Renisa Mawani refers to as the ocean as method. I trace entangled histories with an attendance to the aquatic rhythms of the ocean at the turn of the tide that we stand before, where, as we are reminded by Mawani, international law has historically been made and often forgotten on the decks of ships that traverse the oceans, not always in colonial frontiers or in bureaucratic basements. These are boats indeed alive with possibility, voyaging towards sites of hope and state terror, boats like those that sail in the Global SUMUD Flotilla. My central argument in this presentation is that it is impossible to divorce the blockade from the logics of settler colonialism, genocide, and imperialism, as well as the logic of Zionism itself, which is inherently genocidal, living and dying as it does in the persistent haunting of the ongoing Nakba. I'm working with some new research here, so I'm trying to, as Frans Fanon urges us to do, to think in question marks, perhaps. But in this light, I'd like to trace 5 imperial drives which interlock in the colonial siege and its history, structured by and structuring of settler colonialism. These include, number 1, the imperial drive to cultivate agrarian land to feed the voracious settler and literal appetite of imperial armies, or the colonial kitchen of the kibbutz. Number 2, the imperial drive to dispossession that expropriates colonized peoples of their arable land or settlement by starvation. Number 3, the imperial drive to starve a people into submission or starvation as strategy. Number 4, the imperial libidinal impetus to gratuitous and fetishistic violence or the starvation as seduction of the settler. And number 5, starvation as a mechanism of death-making or massacre by malnutrition.
What I'm going to suggest as I move with some kind of fluidity through some of the historical conjunctures of siege throughout history is that all of these appear in different and interlacing forms in the history of starvation. And therefore, we need to understand starvation not as ancillary or accessory to genocide, but as both structured by genocide and genocidally structured itself. This argument then gives way to two intertwined imperatives as I read it at our present juncture. Number one, to end the blockade immediately, as the freedom dream of the global SUMUD Flotilla invites us to do. And number two, simultaneously, to eviscerate the settler colonial project that both makes possible and is made possible by the siege. Just as we bear witness to the settlement and subjugation by starvation, so too can the settler itself, the settler colony itself, be starved of its cultural life force and sanctioned of its arsenal and economy of death-making. Writing in 1961, Frantz Fanon notes that, quote, under a colonial regime, man's relationship with the physical world and history is connected to food. He continues, in a context of oppression like that of Algeria, about which he was writing, for the colonized, living does not mean embodying a set of values. To live means simply not to die. These words are pertinent in a context of the unhumaning death machine that is Zionism, where Israeli officials speak of human animals with impunity. Across the world, colonial genocide and exploitation has been brutally accompanied by man-made famine, from the genocide of the Overherero and Nama people in Namibia at the beginning of the 20th century, to the treatment of food as contraband by Vatel and Grotius, the latter of whom was both the father of international law and the legal advisor to the Dutch East India Company, whose mercantile unspoken reign saw countless indigenous, incarcerated, exiled, and immigrant communities live and die under the yoke of starvation and as mercantile elites plundered resources. In the Nazi Holocaust in Europe, another colonial genocide, Raphael Lemkin details precisely the kind of colonial caloric control that has characterized the siege on Gaza, that was seen in the racially disaggregated distribution of food in the Nazi Holocaust. These questions are, of course, closely linked to ecocide, which, while attracting significant legal attention more recently, finds its effaced providence in the legal archive of response to the ravages of Agent Orange in the Vietnam War. Bearing this in mind, questions of famine cannot be detached from questions of land itself. We live and die in continuities of Lebensraum, where colonial genocides operate on similar logics of the guarantee and manipulation of terra nullius by any means necessary. As Devon Giatella reminds us at Palestine Studies, the colonizers come and go, but the land remains, and so do our souls. Turning more specifically to Palestine in the context of siege and settlement, thinking with and against the blockade from Balfour to Bibi is illustrative of the centrality of siege to the project of the ongoing Nakba, because the Nakba never ended. The blockade cannot be understood without situating it in the context of the Nakba as the foundational condition of subjugation, fragmentation, epistemicide, ethnic cleansing, and dispossession that characterizes Israeli settler colonization of Palestine. As I understand it, it is for this reason that Palestinian legal scholar Rabia Ikhbaria makes the case for the Nakba as a legal concept, an urgent call not necessarily for extended juridification, but for an accurate understanding of the death-making properties of Zionism and the temporal cartographies of forgetfulness, to borrow from Darwish, abstraction from materiality that is involved in Nakba erasure. Drawing on Ikhbaria's imperative to take the ongoing Nakba seriously as constitutive in our legal and political analysis of Palestine, it is crucial in our resistance, legal and otherwise, to the siege on Gaza to recall that one of the key architects of the Zionist project was also the Manichean mastermind of the Nakba, who was also the Manichean mastermind of the Nakba, Arthur Balfour, was also a central author of the legal logics of and impunities for the history of blockade. Indeed, in 1918, a year after the Balfour Declaration was signed, Balfour hosted Western Allied states in the fascist metropole of London to discuss what was to become of Kaiser Wilhelm in the aftermath of the First World War. And this was a moment that is treated, obviously, in international legal history as a moment in which the course of international criminal law might have changed. And one of the reasons that it wasn't to go ahead in this fashion was because the Allied forces, and indeed under Balfour's command, had exerted such extensive blockades on North Africa and Central Asia and Central Europe that hundreds of thousands of people died even after the armistice was signed. Balfour went even further. In pushing for the extradition of the Kaiser, he suggested a blockade on the Netherlands, which was a so-called neutral state in the First World War, to coerce them, to subject them to starvation and cause them to submit to the extradition of the Kaiser. So Balfour was an architect of the blockade, and we see his imprint in the Zionist project, in the project of the Nakba, which he authored through the Balfour Declaration. In this sense, and again, returning to Ikhbariyah, if the Nakba is a logic predicated on fragmentation of land, of territory, of peoples, it is also an epistemic universe of fragmented knowledge. Rather than seeing Balfour, the British international criminal justice advocate, and Balfour, the harbinger of the Nakba, as two separate fragmented people, we may think with W.E.B. Du Bois to follow the footsteps of men between the various places in which they colonize and occupy. 5 minutes. Thinking along these lines, we might understand the blockade as central to the settler colonial logic of Nakba that haunts the Palestinian Holocaust, The Hague, the high seas, where the siege on Gaza condemns Palestinians to the largest concentration camp on earth. It is this siege that will be broken towards a free Palestine. With this in mind, I want to return to Frantz Fanon, who writes, "Oh, my body, make of me always a man who questions." In this spirit, rather than offering the certainty of an answer, I want to pose several questions I hope we can think of together going forward. What emergent anti-colonial legalities might the flotilla trace at sea? What paths of silenced fragments may we receive and revive and reimagine in the archive of colonial salt and settler subjugation at the end of international law? What imaginaries of international justice and liberation, from Palestine to the DRC, from Sudan to Haiti, from Tigray to Turtle Island, from Indonesia to the United States of America, to Australia, to France, are heralded by anti-colonial imaginaries within a colonial legal architecture? What does tampering with state terror and tyranny, using its tools, as was the case in the South African ICJ case, prevaricating the work, the Global SUMUD Flotilla, the Gaza Tribunal, the work of WOLAS, what does this herald for international law, and more importantly, for those subjugated by colonial genocides? And finally, what might, paraphrasing Palestinian poet Mahmoud Darwish, memory for forgetfulness of the archivally thwarted and artificially truncated long history of anti-colonial lawyering, tell us about the justice jetsam in the cascade of freedom between the river and the sea? I do not know yet what the Global SUMUD Flotilla will herald, but I do wish to imagine that in the justice jetsam along the way lie fragments we can collectively follow and fashion for freedom from the river to the sea. Thank you.
Thank you very much for that. We're going to move swiftly on to Heidi Matthews. Don't worry, you're okay with time. You're absolutely brilliant. Thank you. You were great. Heidi Matthews is an assistant professor of law at Osgood Hall School, Osgood Hall Law School at York. in Canada, not the UK. I can assure you that she has just arrived today from Canada. You are in Tunis today, just to let you know. She researches and teaches in the areas of law, of war, international criminal law, and law and sexuality. And we welcome you to and invite you to take the stand. Thank you.
It somehow have ended up with 3 separate devices with notes on in the course of listening to all these wonderful presentations. So thank you to folks who have managed to stick it out and remain with us. Yeah, we're living it, right? Okay, something like that. Okay, so okay. So I have a few different purposes here today. So the first, I think, is to just identify my own, and Joe too, who didn't get into it, but Joe is also accompanying me on this accompaniment mission. So Joe and I are both going to be members of a human rights sort of fact-finding and legal analysis boat that is going to accompany the flotilla leaving from Tunis when it does leave. And the purpose of that mission is not to break the siege, but to follow, document, and provide real-time analysis for the public and after the fact with respect to any violations that may occur. And so, so just a note that that's what we'll be getting up to in the coming days. And I think that informs.
No, just stop there. Heidi and Joe, thank you very much for going on the boat. Very brave. Could we have a round of applause, please? You don't speak of it as if you're just going to a library.
I'm actually thinking about it like the break that I've never had since the pandemic. So that's kind of how I'm conceptualizing it, mostly because I'll be in the presence of such wonderful humans that will be so energizing and again, so hope-filled in the way that Francesca and Penny and others have emphasized for us. And so it's I think, important to bring that up as well. So I don't have a whole bunch of time, so I have definitely more notes than I have time for, but I'm gonna start, I think, by trying to articulate, at least for myself, how I combine my own pedagogical and research projects with this direct action, right? And how those things make sense and why the action of joining the flotilla in this specific way as an international lawyer and also, and actually more so, a legal academic. My principal job, of course, is teaching students about the law, including international law. So how these things come together. I have left my students. We started term again in Canada last week, nuttily. So we are well into term already. I left my students yesterday with an explanation of the mission and the mission statement, et cetera. And they also sent me away with this great sense of hope and solidarity. And so I want to be attentive to all of that kind of as a package in a way I hope that will make sense for people and provide an extra layer of sort of moral justification, if not also legal justification for the purpose of this kind of action in the present genocidal moment. So I think I might, and if you would just let me know when I'm running out of time. Thank you. Okay. So I think I'm going to phrase the question for myself, which I will then try to answer for you in terms of what does it look like or mean to be an honest scholar, right? That's a very highfalutin kind of thing, but if that's what I am, to try to be at least an honest scholar of international criminal law and colonial genocide in the age of this intensified period of genocidal violence in Gaza. And so that compels me to reflect on my own positionality. So this is going to be my positionality statement, but something a little bit more meaningful than the gestural sorts of positionality statements that we often find in these spaces. And so as noted already, I am Canadian. I'm a Canadian citizen, but more specifically, I come from the island of Newfoundland, which is an island in the north Atlantic, it's close to Greenland, that just happens to be Canadian. In fact, we actually like to talk about ourselves as the first state to liberate itself from Britain, because we had a brief period of failed independence early in the 20th century, right? And so that's the narrative that white settlers such as myself tell about our existence on that land. And part of my scholarly work with respect to the question of colonial genocide in what we call Canada today and what many Indigenous peoples in North America refer to as Turtle Island, that is a far different story, right? So what I want to do is actually acknowledge the fact that it is complicated. Like, the story is complicated, right? But then the responsibility and the task is to sit with those complicated stories and to unpack the complexities and, again, the sort of duties that attend to those narratives. And so I can only come at this, as we all do, from our own positionality. So I come from this place called Newfoundland in the North Atlantic. We have a history, my ancestors came from Ireland as colonial subjects and also from England, differently subjugated in their own ways in the course of the 18th century to settle on this island. Turns out there's actually a native population, what we call an indigenous population there, referred to as the Beothuk people. The only way in which we knew about these people was through the Natural History Museum in my town, because they were declared extinct, using this language of natural history in that very colonial sense. They became extinct, as it were, in 1829. And this, it turns out, was the result of a process of starvation, okay? So the Indigenous people on the island that I was born and raised on, and that my children, I'm now allowing to go to school there, and I do this weird commute back to Toronto, and so I have this weird attachment to this colonial space, right? So it's complicated. They were forcibly displaced from their traditional hunting and fishing and gathering areas along the coastlines. Who went to live on the coastlines? My ancestors, what did they do? They fished cod. What did cod do? Cod fed enslaved peoples and was a central element of the triangular slave route. We also used our lumber to build boats for enslaved peoples, right? And in the process of doing all of that, we also forcibly displaced an indigenous population that then became extinct through a process of starvation that took roughly 200 years to fulfill itself, right? So it's a story of this long genocide that we haven't to this day even been able to approach that language. So this is a little bit, I know, a little bit of a long backstory, but I'm coming to something here. In 2019, we had a national, we being the state of Canada, instituted a national inquiry on missing and murdered Indigenous women and girls, right? Which is, of course, just a travesty that is a reality in Canada, in the United States, and other places in the world as well. That inquiry issued a supplemental report that described that violence as genocidal in nature, okay? This generated a massive backlash domestically, predictably, for the obvious sorts of colonial reasons, right? And many of the proponents of that backlash were folks who were attached to this Holocaust prototype of genocide, right? We could only understand what genocide could possibly mean through the lens of the Holocaust. And Canada's former Justice Minister, Irwin Cotler, now head of a human rights, self-styled human rights organization, said very openly and continues to say, well, if we call that a genocide, then we'll have to call everything a genocide and the word will cease to have meaning, this kind of typical refrain, right? That particular individual, unsurprisingly, has been a vocal opponent of the use of genocide language when it comes to describing the current violence in Gaza as well. So these are the sorts of layers that I just want us to meditate on for a moment. Okay, so being honest means studying these violences at one and the same time and mapping the interconnections and then being honest also in the classroom. So I mentioned my students earlier, and I want to be really honest again about who has been leading the charge. And I'm here talking about the English-speaking world by and large, or maybe even the broader Western world, in terms of pushing back on this genocidal violence in Gaza. And the students have been at the forefront of the activism. It hasn't been the professors. It hasn't been folks who think of themselves as, part of the intelligentsia or holding power in one sort of way or another. It's been the students. And they have faced a backlash that has been relentless, that has consisted in the blacklisting campaigns that we all are well aware of, et cetera, right? So, yeah. So part of what I wanted to do was just to acknowledge that it's not me that's some kind of hero for participating in a part of the flotilla that's not even trying to break the siege, right? I want to acknowledge the students who have come before us and the young people who are part of the flotilla that has departed and will depart soon in Tunis as being central leaders in this process as well. And so there's a certain discomfort that I have in even standing here to talk about, these questions in an academic setting, where I think actually the reality of what's happening in terms of consequence will not come down to what scholars of international law will have to propound to you. Is that even a word? I'm like 36 hours sleepless. Will propound to you about the nature of this or that law. So law is important, but I'm going to pull on some things that Penny said earlier, and also Hussein and some others, around the fundamental limitations of turning to legal frameworks when we're considering the emancipatory or liberatory potential of the flotilla in this moment. And so in doing that, I'm going to just really briefly do a funny thing. I'm going to quote Nazi lawyer Carl Schmitt, who I've been obsessed with for some time. And one of his more famous and least understood quotes is this idea that it's the sovereign who decides on the exception, right? That generally, as I said, I think has been misunderstood. The way I understand that is actually an invitation from that side, right, from a Nazi genocidal sort of political positionality, an invitation to actually do what Hussein had invited us earlier to do, in other words, expose the facade of liberal humanitarianism and inscribe a new precedent in the grammar of liberation, right? So he was doing that in the grammar of oppression, right? But my point here is that once you pull back, that facade and you start to reveal the structural limitations of the thing that we call liberal humanitarianism, you can do that from the other side as well. Right? And in fact, we have to. So when Israel calls the blockade lawful, right? When Israel, or Ben-Gvir, as he did a couple of days ago, called participants in the flotilla Hamas supporters who needed to be treated with the same kind of force that would be necessary to have a deterrent effect on terrorists, right? This is the language that's being used, right? We are sort of happily sit here as liberal lawyers and think of that as a disturbing use of lawfare, right? So law in the use, in the service rather of pressing a specific political agenda. But what I think is at the end of the day really essential for us to realize as actors who want to be honest in our scholarly work, who want to be honest in our teaching, in our social lives, in our familial lives, and in our activist lives, right, is that actually we need to sit with this idea of lawfare, right? We need to use the law for overtly political purposes, to be honest about it, to be smart about it, right? And to accept that as the mantle, right? The essential component that's required, again, if we're going to expose, pull back, and then essentially disintegrate the facade of liberal humanitarianism and all of the colonial and neo-colonial ills that we know go along with that. I am probably out of time, so last minute. No, it's I'm much more exciting to have questions from folks. So, thank you.
Thank you very much. Thank you. We'll have questions at the end, and oh yes, and I'm going to pronounce the surname. Dr. Coralie Pizon Hindawi. Is that good? Thank you. You worked as associate professor in political studies in the American University of Beirut, and you are the author of a book on the use of coercion against Iraq. Is that correct? And your works also engage critically with the doctrine of responsibility to protect. I'm a fan of that. Exploring notably the role that individuals may be acknowledged as playing in the struggle against mass atrocities. Please welcome.
Thank you very much, and I'd like to thank the organizers of today's event, the institutions that made it happen, and more importantly, the individuals that within the institutions in various capacity came together to discuss the legal implications of the siege and the project to break it and reunite with our Palestinian brothers and sisters. So thanks for inviting me and allowing me to modestly be a part of it. It's an honor. In my presentation, I would like to focus on the applicability of the responsibility to protect a principle that you'll see I shortened as R2P, but this is referring to the responsibility to protect. So I'd like to focus on the applicability of R2P to the situation in Palestine and Gaza most particularly, and discuss the usefulness of the concept as the global SUMUD flotilla is getting ready to sail towards the Palestinian shores of Gaza. What's R2P to start with? It's a principle that was unanimously adopted by all UN member states during the 2005 World Summit in September, so precisely 20 years ago. There are different versions of R2P, but the most authoritative one is the one that was adopted back 20 years ago, and that's included a few paragraphs in the World Summit outcome document. What does it say about R2P? To a large extent, this version of R2P as adopted back then is a reminder of already pre-existing legally binding obligations for states. The 2005 document entails an acknowledgement by member states of their responsibility to protect their populations from 4 categories of crimes: genocide, war crimes, ethnic cleansing, and crimes against humanity. This is this acknowledgement by states of their own responsibility to protect, at the very least, is referred to as the first pillar of R2P. R2P also entails a commitment to for the international community to encourage and help states act responsibly. And that's the second pillar of R2P. It refers to the responsibility for the international community through the UN to use appropriate diplomatic, humanitarian, and other peaceful means. But they're the third pillar as well to R2P. Should these peaceful means prove inadequate and the authorities are manifestly failing to protect their populations, R2P specifies that the international community may take collective action in a timely and decisive manner through the Security Council, including through coercive measures resorting to Chapter 7 of the UN Charter. The 2005 document also refers to the need for the General Assembly to be involved and continue consideration of the responsibility to protect populations. This possibility to use coercive means, including military force, this is referred to as the third pillar of R2P. If we sum up what we have, with R2P. We have a concept that really focuses on the tip of the iceberg when it comes to human rights violations. There is obviously so much more that states should do, but the absolute minimum is abstaining from massacring people, and that's what R2P is about. A second important point is that R2P does not create any, or did not create any new legal obligation. It really reaffirms pre-existing obligations. Now, turning to the question of R2P's applicability to Palestine and Gaza most particularly. R2P is triggered when any of the 4 crimes mentioned, genocide, war crimes, crimes against humanity, ethnic cleansing, is occurring, is being committed. Some scholars tried in 2014, that was already in relation to Gaza. Some scholars try to argue that R2P would only be applicable when a state commits atrocities on its own territory, so not on a foreign territory it would control. This, we showed, is an argument that really contradicts the very purpose of R2P, because precisely the whole point of R2P is to say it's applicable everywhere, anytime, for any people that would be subject to the crimes we mentioned. Whenever the state or states in charge are unable or unwilling to offer protection. So we have an astonishingly clear pattern of well-documented facts and legal analysis. We know that Israel is currently engaged in all 4 of each of the crimes that on its own could trigger R2P. So it's crystal clear that R2P is applicable. And I think it could safely be argued as well that R2P has been applicable for years prior to the current violence. And for those interested, we organized a virtual roundtable back in 2019 discussing the applicability and usefulness or relevance of R2P for Palestine, which is online and easy to find, and unfortunately continues to be even more relevant today. So the question that one could raise is, if we agree that R2P is clearly applicable, the question is it useful? What's the point of highlighting R2P's applicability when really clearly binding norms, such as the prohibition of genocide, which really has the highest legal value as a peremptory norm of international law, when these norms are being violated anyway, and we're struggling with their enforcement? What does the reference to R2P add, and isn't it a waste of time? I've been thinking about this quite a lot, and I've come up with, or I'd like to mention a few reasons I see to invoke R2P in connection to the genocide. First of all, R2P is a tool whose invocation can help protect Palestinians. And in this deeply unequal, asymmetric fight, I consider we cannot afford to dismiss any tool. It's a tool that's often portrayed as a European brainchild. This is misleading, actually, and inaccurate. And there is plenty of evidence showing that R2P is to a large extent the outcome of Southern, most particularly African advocacy agency and norm engineering. But this widespread perception that R2P is a Western tool can serve us to increase pressure on former self-proclaimed R2P champions. And in that sense, I think it is a pity that the principle has been so far been really rarely used when calling for actions to stop the genocide. Yeah, don't worry, it won't be long. So I'd argue that we need to invoke R2P more And it's a timely moment to do so, as this month is marking the 20th anniversary of the concept endorsement. One of the things that R2P scholars struggled a lot with is the question of agency. Early on, there was a concern that the sort of broad references to collective responsibility would diffuse that responsibility, which is likely to lead to no one taking responsibility. Why, according to the thinking that why should I be the one to take responsibility when everybody else could and should equally do so? But from my end, I would argue that the language, this language of responsibility, and this sort of broadly defined, that it actually can be useful. And I like to argue that the concept of R2P, the language that it uses, and the fact that it is a concept really at the crossroads of legal, political, and moral spheres, and makes it a useful framework, notably for actions undertaken by actors below the state level, down to the individual level, in reaction to what some of us sense and know is wrong and that we just can't let happen, which leads us to take responsibility and to try and do things at our level. So in that sense, I do believe that the R2P concept can be a useful framework for the global SUMUD Flotilla action, because it simultaneously reminds states and international organizations, so the traditional, sorry, I got lost, traditional actors that we have in mind when we talk about the international community. So R2P simultaneously reminds them of their legal responsibilities, and I think it's crucial. We all acknowledge they are failing, but I do think it is crucial to continue to hold these traditional actors accountable in all possible ways, including using the R2P principle. But R2P also can encompass the moral responsibility of individuals, as most impressively with the global SUMUD Flotilla participants, but also millions worldwide. Thinking of Heidi's students, among many others that she just referred to, willing to take responsibility in reaction to crimes they want to stop. I'd say that we too are actually part of this international or global community, and we need to look at ourselves as part of it, an integral part of it. So I do look at the global SUMUD Flotilla, the Gaza Tribunal, the lawyers organizing to pressure state representatives, prosecute Israeli soldiers, the militants organizing actions and demonstrations. I see all these initiatives actually as an integral part of R2P under the second pillar, these non-violent, peaceful initiatives to exert pressure. And that, of course, is a burden for individuals to take on, going against a country supported by many of the world's most powerful states. But we are millions across the globe trying our best to be the international community that we need. And in doing so, we are embodying the fundamental norms of international law we want to see upheld. As Melanie was saying this morning, Schweitzer, the ships will be carrying international law. And from this perspective, international law and the responsibility to protect look, I believe, very much alive and very strong despite everything. Thank you.
Thank you very much for that. Our final speaker today is Mohammed Halawa Baddar, who is a professor who holds the chair in comparative and international criminal law and Islamic law at Northumbria Law School at Newcastle, United Kingdom. He's a former prosecutor and judge in Egypt, and he is a single author of the concept of mens rea in International Criminal Court. His recent research is focused on the significance of universal jurisdiction in the case of international crimes. Thank you.
Thank you, Mr. Chair, and I may start one sentence in Arabic. I'm Egyptian. فخور ولي الشرف أكون بين أهلي هنا في تونس الخضراء كوني مصري الجنسية، وشكرا لفلوتيلا وشكرا لكل الشجاعة and the courage. And I'm looking now at the very nice poster. We sail to Gaza to break the siege. نبحر إلى غزة لكسر الحصار. And why did we reach this point? And why the international community failed and the international law failed and governments failed, and not only failed, not only a passive role, no, they play also an active role, being complicit in genocide. Why did we reach this stage? Just think about it. We reached this stage because I believe that international law has taken a long nap, being threatened, put on hold by Western power, which they prove that we are in the era of double standards. Other colleagues said it in better terms, that we can see now the real faces of double standards when it comes to the implementation of international law. Does it mean that we have stopped there, or we have to take some action, some legal actions? So sometimes you have to think outside the box. What I will do now in my presentation, in this 12 minutes or 13 minutes, I have like two parts. The first part, I will focus on what happened to international law. It's not just today, or it's not just 2 years ago. I witnessed this starvation policy 25 years ago when I was in Ireland, and I proposed to write a PhD on starvation and slow motion genocide. And I was discouraged to do it because maybe at the Viva, at the defense, the external examiners will be Western and they will tell me you are relying on facts, which is maybe a bit disputable. So please don't do it. And those who discouraged me, they are the authority of international criminal law by now. One of them passed away. So I was discouraged to do my PhD on starvation and genocide or death or slow motion genocide by starvation 25 years ago in Ireland. Now, so what happened to international law? And that's so we have a legacy of Israel and the legacy of impunity for the past 77 years, for the past 70 years, 7 decades. Have you ever witnessed or experienced or remember someone who stood trial from the Israeli government for any of the crimes took place in the past 70 years? No. So we have the legacy of impunity, a historical perspective. Just I want to go through it with you. And then how can we break this silence? Because we have really silence for 70 years. The law is not active, or the law is silent. International law is silent. When it comes here, yes, we have impunity. And I will propose in the last 2 minutes universal jurisdiction in absentia. I will propose suggest to all the Arab countries, most the majority states. I will not speak about Western states, leave them alone. We don't need anything from Western states anymore. We have to empower ourselves. I'm talking also to our generation, new generations. I'm talking to Arab legislations, most the majority states legislators, that you have to legislate the law like the West. They used to use or exercise universal jurisdiction against global South. It's the time now to be equipped. Whether you'll use it or not, who knows? But we have to be equipped with legal tools, which we can use it at the right time. And I don't think that's the more right time than the time now. What is universal jurisdiction absentia, and how can this empower domestic courts willing to end impunity against Israeli senior officials, soldiers? Here is the historical background. The first 1948 Palestinian Nakba. Genocide does not cover what's going on right now. Nakba did. And now we are witnessing the second Nakba. Nakba is destruction of everything. A colleague in the morning said it's not only destruction of people, destruction of the hagar, destruction of the stones, destruction of buildings, destruction of everything. So it's real Nakba, what we are witnessing now. So the Palestinians survived the first Nakba. Yes, they did, but 700,000 at this time vanished. They left home, and we continue. So we have a policy, we have a systematic policy of erasing, destroying the identity of people with a plan to get rid of everyone in Palestine or in Gaza. President Trump, he made it very clear a few weeks ago, a couple of months ago, we need Gaza to make it as a Rivera. And someone asked him, but under which authority you can let these people out, Mr. Trump? I said, under US authority. I am telling you, the international law is in a coma, ghaibuba, nap, whatever you want to say. And my problem is, I said, Mr. Trump, be aware, what you are saying could lead to you to be accomplice in genocide. So then we have the first Intifada. And the first Intifada here is very important to know that it took place in 1987 to 1993, just throwing stones against the occupying power, against Israel soldiers. And of course, there is disobedience and trying what? Trying to let the international community, we are here and we are trying to have our land back. The problem, I can see it here, that after the first Intifada, we have a Security Council, and maybe this is the first one. Sorry for this. Security Council Resolution 242, 1967. And that was the first Security Council resolution being not respected. So it's not now, a colleague of today said, we have more than 30 Security Council resolutions not being respected. I'm telling you, it's systematic. That's the history. Israel continued not to respect. Israel continues the legacy of impunity. And then we have the International Court of Justice, decision, advisory opinion after advisory opinion. Again, we have advisory opinion, we have provisional measures, and none of them was implemented by Israel. Why? Because not only Israel, but again, Western powers are behind the non-implementation of the Security Council resolution. And now, of course, we can see the United States, how many times they use the veto in order not to have a ceasefire or anything which improves the situation in Palestine. We have the whole advisory opinion by the International Court of Justice in 2004. I will not go through all the decisions, but you can see in 2004, we have advisory opinion as requested by the General Assembly of the United Nations, tell us exactly. The ICJ, or the International Court of Justice, found that Israel is violating all the international human rights provision, a lot of international humanitarian law provision, and what else? What happened in 2004? Have they knocked the door? No, the wall is still, sorry, the wall is still there, and it's 700 kilometers till now. Right of self-determination being denied. And I want to pause here and to tell you what I believe and other scholars believe and institution believe here. I believe that there is an apartheid. The government of Israel, they don't want to be apartheid state like South Africa. So the only thing to escape from apartheid as apartheid state, to do ethnic cleansing. Get rid of the people. And there is no people. There will not be one in Palestine after they deport them, hopefully not. And then we're not apartheid state. So when history will say, no, we didn't do it. But hopefully soon we'll see a court decision about, on the merits from the International Court of Justice, that what happened in Palestine by the Israeli is genocide. We are waiting to have a court, ICJ court, or a judgment on the merits. Maybe people say, maybe we'll see it 2027. Whether the Palestinian will survive till 2027 or not, this is another question. Now, we have the provisional measures, and you see the order, and they ask Israel also stop inciting for genocide. And you can see 3 days ago, they continue semi-official inciting for genocide in Palestine. The International Criminal Court, I have to say, they did their best. And as you can see now, they freeze the asset. And if you have bank account in the United States, they will freeze it. If you are a judge, if you are a prosecutor. So we have United States fighting the International Criminal Court because you want to apply justice. Again, it's a very schizophrenic way of justice, or I'm not sure why the United States is doing that. But again, like colleagues said today, we have many countries, and it was said today by scholars, or 2 days ago by Professor William Schabas, Germany, United States could be accomplice in genocide. And I think William Schabas is an authority on genocide, and he mentioned just 2 days ago, Germany, United States, and others could be accomplice of genocide. I want to pause here, and I'll speak about genocide for 30 seconds. The Genocide Convention is not called the Genocide Convention to punish, no, to prevent and punish. The international criminal law failed something called the preventative measures. You should prevent, because failing to prevent, the nation will be destroyed and will be vanished. So it was to prevent. Outright to prevent, no, but again, that's the failure of the international community to prevent people or nation to be vanished. We have the prosecutors here at the ICC, maybe Dr. Polona Francis spoke about it, but I will not go through it. But again, the ICC is facing a real problem by the United States. We have defense team. I'm not sure that also we will see any of the big figures or senior figures of the Israeli government before the ICC, because it means that we need state cooperation. So what I would like to do, that's the non-exclusive list of notable entities and scholars describing the war on Gaza as a genocide, and that's Professor Schabas saying, yes, US, Germany, and others could be held liable as accomplices to genocide in Gaza. By the way, the Genocide Convention, there is an article on complicity. When they were drafting this article on complicity, the mind of the drafter is not accomplice liability for individuals. It was complicity of states. And you can see now the complicity of states, not only individuals, in committing this genocide in Gaza. And the last point here, with this culture of impunity, should we stay powerless as lawyers, or we have to think about something else? And that's all I would like that we think about. To break the silence, we have to use universal jurisdiction as a means to end impunity in Israel. And universal jurisdiction means, in a very simple terms, and I'm so happy to speak about it later on. Universal jurisdiction means that state A has no connection with the crime took place in Palestine because the victim is Palestinian. The accused or the alleged perpetrator is Israeli, and it took place on the territory of Palestine. Whether or not Algeria could prosecute this crime, yes, based what? Based on universal jurisdiction. It's not a phenomenon. It's a conception, a tool used by Belgium, by all Scandinavian countries. Now it's something wow, but it was never used by global South country against Western. It's always Western against global South. So I'm not saying something, I said now it's time for most of the majority states to empower themselves by new legislations. You have first to incorporate international crimes into your legislation. You cannot say, yes, I will prosecute
Professor.
X for this. And the last point is, we have a golden opportunity. We are follow this francophone when it comes to the procedure or criminal law. You can trial someone in absentia. So the victim will be heard. You will bring all the victims. Justice for victims is not justice for... Bring the victims, they will tell the story. The story will be heard. We'll be writing history.
Professor.
And after that, if the perpetrator will appear, you can have a second trial from the beginning. But at least you preserve all the evidence, because one day there will be a trial against these senior figures. Thank you, and happy for any questions.
Thank you very much. I'm very sorry I had to cut you off. The only reason is that they need to close the building, and that's why I've been interrupting you. I'm afraid I understand there's not going to be any time for any questions. I did not want to say this sentence at all. Is that correct, Hussein? Yes. Hussein, I'm going to ask you to close the program because you've been behind all this. And a round of applause for Hussein, please.
Thank you very much, everyone. Solidarity among academics is not a usual thing, and it was really inspiring for the participants as well, but even for ourselves. So thank you for being here. Thank you for the audience. Inshallah, we will cheer up when the ships sail to Gaza, reach out to Gaza. Can we